Good morning and welcome back to the March 22nd through 24th meeting of the Legal Affairs Committee of the 2020 California Citizens Redistricting Commission. We will take public comment in just a moment. Today we have 3 interviews, just as we did yesterday. Those will begin at 10 a.m. The second one at 11:10, the third one after lunch at 1:05. Let's go ahead and take public comment. Christian?
In order to maximize transparency and public participation in our process, the commissioners will be taking public comment by phone. To call in, dial the telephone number provided on the live stream feed. It is 877-853-5247. When prompted, enter the meeting ID number provided on the live stream feed. It is 935-6444-6340. When prompted to enter a participant ID, simply press pound. Once you've dialed in, you'll be placed in a queue. To indicate you wish to comment, please press *9. This will raise your hand for the moderator. When it is your turn to speak, you will hear a message that says the host would like you to talk. Press *6 to speak. If you'd like to give your name, please state and spell it for the record. You are not required to provide your name to give public comment. Please make sure to mute your computer or live stream audio to prevent any feedback or distortion during your call. Once you are waiting in the queue, be alert for when it is your turn to speak, and again, please turn down the live stream volume. And there are no callers in the queue at this time, Chair.
Thank you, Christian. On the question of contributions also, I don't know if it's entirely clear, especially extremely large firms, whether we are expecting, reports on anything anyone in the entire firm had ever done. That would be reams and reams of reporting. So that might be a lesson learned for next time.
The instructions are complete on the live stream, Chair.
Very good. Please keep the line open. And meanwhile, we can continue in our discussion. So on the matter of reporting conflicts of interest and campaign finance, campaign donations, do we want to pursue any further thoughts on that?
Well, I think, just for folks who may or may not be tuning in, it might just be helpful to say that I was attempting to review and get input from Ms. Yang, the representative from the Attorney General's office, who's here with us to provide counsel on procedure. Looking at, and I think it's valid to raise this, given that we've had several pieces of public comment at this point, which have pointed to potential concerns regarding disclosures. Of course, in our office, our paralegal, Ms. Keller, provided a very detailed report of all giving that's occurred. We didn't ask for all giving. We asked for compliance with California Code Section 8252, which is somewhat more specific to contributions over $2,000. Looking more closely at the RFI, I think there's some openness to interpretation here about what this could include, whether that would include all members of their firms, right, or the individuals listed on the applications themselves. I think most people read that as the individuals who are part of the application, and I think that seems like a reasonable interpretation. I think there's also some question that has been raised in some of the responses from our applicants about whether or not we meant only those donations or lobbying activities that occurred in the state of California, or if that also included other donations outside of California. I think that was raised also. And again, the language used in the government code is not entirely clear on that point. And so I think it's reasonable to read it as only those in California. I think for many of our applicants, when we conducted the report, most of them replied, not all. And so I think it is fair perhaps to ask applicants to provide additional detail on their lobbying activities or donations during the interviews if we see it necessary as a follow-up question, if we feel like there was anything not being disclosed. Is that a fair assessment of where we're all at?
Mm-hmm. I believe so. So the relevant code 8252 addresses the standards for commission members themselves, and these particular conflicts of interest, including, for instance, donations over $2,000, are actually disqualifying commissioners, potential commissioners. For our council, they're not automatically disqualifying. We're simply asking for disclosure, and then it's up to our discretion how to weigh those disclosures. So, and we did not ask for donations under 2,000, but we did end up reporting them, and most of the groups, I think, ended up confirming the smaller donations as well. But the fact that they did so should not be taken as a sign of initial unresponsiveness.
Correct. That's correct.
Just a quick procedural question for Council Yang. Since we didn't ask these questions yesterday to some of the applicants, could there potentially be a procedural problem with adding these questions now? I believe it's follow-up, and I don't think there's an issue, but I just wanted to verify.
Oh, I'm sorry, I was on mute.
No worries.
It happens.
It was brilliant, I'm sure.
Oh, I apologize. So I don't see any procedural issues with raising the question with the separate contract for litigation counsel, as the contract yesterday was for a different contract.
Okay.
But I would like to add, though, I think we had discussed briefly just a few minutes before the meeting began as to what candidates might mean. And I'm taking another look at the government code section that was referenced in 8252. And the RFI had required the applicants to provide information in addition to what is required under 8252. Any political contributions, including contributions made by a firm political action committee to candidates as described in California Government Code Section 8252 during the past 10 years. And so if you look at 8252, the provision regarding contributions only mentions congressional, state, or local candidates for elected public office, but the section also refers to candidates for federal or state office and a candidate for elected federal or, a candidate for a federal or state office. So I could see that it could be a reasonable interpretation that the commission had wanted to also take a look at whether or not the applicants had made any contributions to federal or state office candidates. Because the government code section 8252 does mention broadly candidates for federal or state office.
Okay, thank you. Any other reflections on yesterday's discussion or questions for today's discussion and interviews? Yesterday, we did end with a preliminary ranking of the 3 candidates for VRA Council, ranking the Stromwasser, Wucher, Becker group first, the UCLA group second, and the Krimkart Aiken group third. If there are no other matters to discuss and no public comments, shall we go ahead and take a 10-minute break and come back at 9:55 and be ready for the 10 o'clock interview with Gibson Dunn. Note that Gibson Dunn has sent in 2 changes to personnel. Instead of Theodore Boutros, they're sending Daniel Adler, and they are as well adding Emily Sauer to their team. We'll have 4 representatives. Okay, so let's take a 10-minute recess, return at 9:55. Thank you. We return to our morning's session, and in a few minutes, we'll begin our first interview with Gibson Dunn. A few more personnel are on the way. For those who may have seen an earlier version of the schedule, note that Gibson Dunn has changed its representation in personnel for this session, with Daniel Adler expected to replace Theodore Boutros and then Emily Sauer being added. However, these are all individuals who were on the original application. This is no change in the team being proposed. Good morning, Mr. Skolnick, Mr. Khan.
Good morning. Good morning. Thank you. And I just say at the outset for clarity, it's not as if Mr. Boutros is not going to be part of the team if we're selected. It's just that he had a conflict this morning come up. So just to clarify.
We understand. Good morning, Ms. Henry.
Thank you.
Mr. Adler.
Good morning.
Ms. Sauer.
Good morning.
Wow, the wonders of Zoom. Here we are.
Exactly. We appreciate the opportunity. Thank you.
Absolutely. Well, we are all here. So even though it's a couple of minutes early, why don't we go ahead and get started? Good morning. I'm Russell Yee, the rotating chair for the Legal Affairs Committee of the California Citizens Redistricting Commission 2020 edition. And we welcome today our guests from Gibson Dunn. We also have present our Executive Director, Alvaro Hernandez, as well as a representative from the California Attorney General's Office, who is on audio but not camera, Deborah Yang. And then the 3 commissioners on the Legal Affairs Committee, myself, Commissioner Toledo, and Commissioner Sadwani. Let's see, Mr. Skolnick, you were the one who you were the lead on the written application. Can I ask you to go ahead and introduce your team?
Sure, and I'll let them introduce themselves. I'll start off. I'm Con Skolnick. I'm a litigation partner at Gibson Dunn in the Los Angeles office. I handle a broad range of constitutional and other claims and have a fair amount of experience in voting rights and redistricting matters. In fact, was part of the team 10 years ago that was honored to represent the inaugural commission, and we worked closely as in our dual role as Voting Rights Act counsel during the map drawing process and also litigation counsel after the fact in the Supreme Court. So this is something I can't believe 10 years has gone by, but here we are again, and you know we're excited. We're excited to talk to you. So I'll hand off to my partner Matt Kahn.
Thank you, Con, and thank you, commissioners, for having us here today. My name is Matt Kahn. I practice in the San Francisco office of Gibson Dunn. Like Con, I have a broad practice, and I handle a number of different types of litigations, including experience in voting rights work. Like Con, I represented the commission in 2011, and I'm honored to have the opportunity to speak with you again today. I've also litigated claims under the California Voting Rights Act, including obtaining the first ever preliminary injunction against an unlawful method of elections in Madera County several years back. So thank you for having us here today, and I'll hand it over to my colleague, Ms. Henry.
Hello, commissioners. I'm Tiana Henry, a senior associate in the Los Angeles office of Gibson Dunn, also a litigator with a broad practice. My primary practice is transnational litigation, but I also litigate a plethora of other matters, breach of contract cases. In the voting rights space, I was the lead associate on the team that defended the city of Santa Monica in the recent CVRA litigation that they had pending against them, and was heavily involved with the experts there, the demographer, the ecological regression analysis expert. And so that's sort of my main area of expertise in this area. And I'll hand it over to Daniel Adler.
Hi, I'm an associate in the Los Angeles office of Gibson Dunn. I'm something of an appellate specialist, and just yesterday, Con and I filed our answer brief for the city of Santa Monica in the California Supreme Court. I've also counseled several cities on how to comply with the California Voting Rights Act. So we have thought quite a bit about that statute and how it might impact our various municipal clients across the state.
Good morning, commissioners. My name is Emily Sauer. I'm also in the Los Angeles office. I'm a junior associate there, and my practice involves several appellate and constitutional matters. Thanks so much for having us.
Thank you. Thank you all for coming. We do apologize for the last minute rescheduling of this interview that was to take place last month. We appreciate your flexibility on that. I should also mention this session is being live streamed to the public, although we will not be taking public comment during the interview itself. We will be taking public comment later today. We do have a standard set of questions that we're asking each applicant team, and we'll rotate asking those questions. I'll go ahead and pass it over to Commissioner Sadwani for the first question.
Thank you, Chair Yee, and good morning to all of our guests from Gibson Dunn. Our first question is very much a standard question. Please confirm the California bar memberships that we for each of your attorneys that would be a part of the team, and address any issues that might arise.
I'm sorry, Commissioner. My audio cut out. Could you please repeat that question?
Sure. It's a very standard question, and I think from our research, it's not entirely applicable for you, but please confirm California bar memberships for all of the members of your team.
That was an easier question than I thought. You're right. Yeah, we are all admitted to the bar, and everyone on the team that we're working as a lawyer is admitted.
In California.
In California, yes.
Yeah. Thank you very much.
Thank you for confirming that. Sure. And then to Commissioner Toledo for the second question.
Thank you, Commissioner. The public must have a high level of trust and confidence in counsel's ability to provide objective, balanced, nonpartisan advice of the commission. How can you provide that assurance?
Well, I would say this. First of all, we're in the unusual position of being the only people who've done it before. We did it last time. Matt and I were part of this interview process last time, and I remember the same concerns being raised, and even maybe heightened concerns, because it was the first time the commission had ever done this. Nobody knew how it was going to go. It was an experiment, but the experiment worked. And I remember questions being raised last time. At the time, this was 2010. There were concerns that Gibson Dunn was too much of a right-leaning law firm, and we were the firm of Bush v. Gore, and Citizens United. Since then, I guess I could see the opposite criticism being levied. We've done work in the Supreme Court on behalf of the Dreamers. We were the ones who championed the takedown of Proposition 8, the anti-gay marriage statute. So I guess I would just say, one, we've done it before, and we were able to provide very, very fair and balanced and nonpartisan advice. Two, our cases and our clients are truly on all ends of the spectrum. Like I said, from Citizens United and Bush vs. Gore to Prop 8, gay marriage, and working on behalf of Dreamers and other immigrant clients. And so there should be no question that we're the type of firm that is not going to sacrifice our advice for any sort of partisan leanings. I would also say, even in the voting rights space, we've represented individual clients who have brought affirmative claims, voting rights claims under the CVRA, under the Voting Rights Act against municipalities claiming violations. And we've also defended, right now, Daniel Adler mentioned that we're representing one of our big matters in the voting rights space is on behalf of Santa Monica, defending against a voting rights claim, a CVRA claim, and we're litigating that in the Supreme Court. So we truly have done it all on both ends of any political ideological spectrum, and I hope there's really no question that the advice we're providing is the best advice without any partisan leanings.
I'll just add on top of that when we did this in 2011, we deliberately put forth a team where the individual lawyers had different political leanings. And we've done that again here too, to just further bolster against any claim that there's anything partisan one way or the other about our firm, so that you can't be attacked for hiring us.
Commissioner Salvani.
Thank you. Can I ask a follow-up question? We've had a number of public comments come in regarding disclosures, not only for your firm, but also for others. Is there anything in addition that you would like to add to the kinds of disclosures that Gibson Dunn would like to make at this time? Of course, we provided your team with the research that we've done in terms of the kinds of campaign donations and lobbying activities.
I guess I don't really have anything to add. I did look at the disclosure or the conflicts report, and it seemed accurate. As we noted, we're a very big California firm, and so we have lots of matters that are both opposite the Attorney General and yet on the same side as the Attorney General. I have a big litigation now against the California Insurance Commissioner, and yet we're on the same side as that agency. So we could talk about specific matters. I probably would need to do a little deep research if you had concerns, but I think the point is that we're all over. We've disclosed that we are very involved in California litigation that involves all kinds of statutory issues, constitutional issues, and the AG is involved on both sides of those. I did notice something in the public comments about a disclosure having to do with a casino. I forget the name of the commenter, but one of the public comments had a question. I just noticed that this morning. I don't really have any more information about that. It's 5 years old. None of the team members on this team had anything to do with that, had that matter. So if it's an issue, I'm happy to do some research and give you an answer. But I don't see that being a particular concern for this team because we're not involved. We weren't involved in that 5 years ago, and we're not involved now.
Yes, and commissioners, if you have any questions, any follow-up, anything more you need, just let us know and we can get it.
Thank you. Very good. I think we can move to the third question now. Given your experience with redistricting, what are common mistakes made by other boards and commissions which result in litigation being brought? And how can we avoid these pitfalls? What action should the commission take now to mitigate litigation risk in the future?
I can handle that one, and I've got a number of responses. I'll say at a high level, though, that this is something that we advise on all the time, not just in the context of voting rights. Obviously, that doesn't come up on an everyday basis. Certainly, we did advise the commission in 2011 successfully to avoid on how to avoid litigation, and that worked out well. But we also, all of us on this call, we represent clients who are in similar positions in the sense that they are taking actions that almost certainly will later be challenged in litigation. And we counsel them in taking those actions on the steps they can take to mitigate those risks and minimize the damage from litigation down the road. It's just one example. We represent companies all the time that are taking corporate actions, including acquisitions and things of that nature, where there's certainly going to be litigation challenging it, and we help work with them to take the steps necessary to avoid that. So let me now get to specifics. So I have a couple of areas. First of all, substance. Substantively, clearly the most important thing to do is follow the statutory criteria for redistricting as closely as possible. Easier said than done, of course, in practice. But doing your best and showing that you're being diligent, thoughtful, and careful in the steps you're taking, and that you have a good, well thought out, thorough process is important. For example, if you make any deviations from the lower level criteria, you need to explain clearly that those deviations were made because of competing higher level criteria. That's the substance. Procedure is very important too and can't be overlooked. And procedurally, it's important for the commission to be as transparent and inclusive as possible. For example, and this may seem obvious, but I don't think it is, you need to make sure to allow enough time at meetings for questions and input. And we know from last time that these meetings can take all day and into the night. And so the commission should plan accordingly to make sure there's enough time and no one can say they were shut out of the process. It's important, we think, and we did this last time, to create written narratives for each of the districts that explains why, as a whole, the districts provide fair representation for all Californians and meet the statutory criteria. Particularly because of the pandemic, it's also important to ensure there's sufficient outreach and access to public meetings, including things like closed captions or sign language, such as we have on this call. In addition to making the meetings available to the public by Zoom or similar technology, we think the commission also should consider advertising the meetings to inform the public the meetings are occurring and public is encouraged to participate. And not just traditional English and foreign language media, but also social media, outreach to organizations on all ends of the political spectrum. So there's no potential valid claim. There will be claims, but no potential valid claim of bias. Finally, from both a substantive and procedural standpoint, we think it's critical that the commission carefully document its work, including the reasons and bases for taking or for not taking certain steps. We did this in 2011. We helped the commission create a really careful, thorough, detailed written record, and it was very helpful in defending the commission's work. We think ultimately the best defense against many possible litigation challenges will be to show that the commission's decisions were thoughtful, deliberate, and evidence-driven, and negate any claim that they were arbitrary or partisan.
Very good. We can proceed to question 4. And Commissioner Silvani.
Sure, thank you. This is a question that's along the same lines, but perhaps you can take a different take on it. If the commission successfully files its maps on time and in good faith compliance with its constitutional requirements, on what basis are its maps most likely to be legally challenged?
Well, maybe I can offer a little different spin. I think, Matt did a great job, obviously, covering what you can do proactively. But the reality is, as you know, you're probably going to draw some lawsuits, and to be less scientific about it, it depends on who's unhappy with the maps. No matter what choices you make, somebody's going to be unhappy. Somebody's going to, in the process, is going to ask the commission to do something that the commission doesn't do because it's balancing 1,000 different interests and different considerations. And so it's likely that there will be someone dissatisfied, and so the claim will sort of depend on what decision the commission made that didn't favor that particular group's or person's interests. So we saw a lot. I mean, I think the best predictor of what's going to happen is looking what happened last time. You had one of the main litigations was a referendum that was directed at the new maps. Obviously, that had a lot of litigation at the Supreme Court level in terms of whether you could stay the maps, what maps were going to be used in the interim. So it's certainly possible, if not likely, that it would be a similar effort to come up with alternate maps and to try and get a referendum process and stay or litigate the maps. We think there could be challenges during the process itself. One of the things Matt touched on was access and how access is going to be even uniquely difficult, obviously, in the Zoom world and Zoom setting, particularly because not everyone has access to the computers and the internet and the Zooms that are going to be the way in which we do this, I think, this time. So we would anticipate, or I think it's possible anyway, that there could be claims during the map drawing process itself. So it's not really what your question was, but just be aware that that might happen. And a particular group or person might claim a denial of access or other problem during the map drawing process itself. But assuming you get through, and assuming you've done everything in good faith, like the referendum process is something. A lot of litigation, as you know, is about race being taken into account too much or not enough. And so depending on what lines end up getting drawn and where exactly you make choices, you could see either or both of those types of claims. I remember last time I was mentioning to our team in South LA, there was a lot of discussion about creating, do you create a majority Black district, or do you create multiple districts in which the African American community has, maybe not a majority, but a sufficient number to be successful. And so those sorts of decisions are going to have to be made. You obviously are taking race into account, but as I'm sure the commission already knows, you just can't have race be the predominant or sole factor. And so there will be claims like that. We think it's unconstitutional racial gerrymandering, things like that. I think you flagged in one of the questions, maybe, or at least in some of the materials, prison issue. Prison gerrymandering is an issue right now that we see a lot of claims. There could very well be a claim challenging the commission itself, the constitutionality of the commission itself. One of your questions dealt with the Arizona case from the Supreme Court. Obviously, the Supreme Court has weighed in, and I'll just give you a preview of our answer on that question. The Supreme Court has weighed in on that, but doesn't stop someone from bringing a challenge. And it's tough to predict where the court would be right now. I think, and I'll just go ahead and answer that question since I'm talking about it, but it depends on where the current justices see the value of stare decisis and about letting the decision from 2015 stand. We could predict that someone like Justice Thomas probably wouldn't give it much, wouldn't be hard for him to rethink a decision issued just 5 years ago, whereas someone like the Chief Justice would be more likely to accept the rule of law, even if he disagreed with it the first time, given that it's now the law of the land. And our newest justices are really hard to predict in that area because we don't know exactly what they're going to do. But the bottom line is it should be the law of the land. It should be the way that the court views the same question if asked again 5 or 6 years later. We have no reason to think otherwise, and there's not much you can do about it in the meantime. So if that comes up, we would help you fight it. But for now, that's just a possibility. And then finally, I think we mentioned these denial of access claims. Those are the ones that we think are very likely in this particular environment.
Very good, thank you. We'll go to question 5 with Commissioner Toledo, and I should mention we're doing excellent on time. We have till 10:50 for this interview. So, Commissioner Toledo.
Yes, thank you, Commissioner Yee. How would you view your role when working with the Voter Rights Act Council retained by the Commission in avoiding potential litigation as well as defending the Commission during litigation? And how would you envision your role in working with the CRC, line drawer, and other CRC staff?
Well, it's a good question practically because there needs to be a very close relationship. That's the bottom line. We need to be in frequent contact. And again, I hate to keep hammering our 2010 experience, but that's the most relevant anyway experience that we have. And we were doing both things. We were performing both roles, and it was essential that we were involved in the line drawing stage to plan for litigation. As Matt mentioned, that's often the case. I mean, as a lawyer, your dream scenario is you're involved in the transaction itself so that you can help shape it and make it as litigation proof as possible. So there needs to be frequent collaboration. We need to understand from the map drawers and from the VRA Council what the issues are that are coming up and help work through them so that when the commission's making choices, it's best advised with litigation in mind and trying to make the maps as litigation proof as possible. So bottom line is there needs to be a lot of collaboration. We would need to figure out a way to do that efficiently. Obviously, you don't want to over lawyer this, and so we would try to have a protocol where we have frequent updates and frequent meetings with our colleagues, but yet not maybe having to be involved in every single session so that you're paying multiple lawyers to sit in on every meeting. That would be the ideal, I think.
And just to amplify that a little bit, you'll notice that we have 5 lawyers here in this meeting. That is not any indication or predictor of what our staffing of this matter would look like. It's just that we wanted you to have a chance to meet as many members of the team as possible. But certainly when doing the work, it would be only probably 1 lawyer per meeting, things of that nature.
Mm-hmm. Yeah, sorry, little coda. Yeah, exactly. There's litigation counsel has 2 phases, right? It's what are we doing during the map drawing process? And I think we would need to be involved, although in an efficient way. And then the litigation itself, which most likely is going to be only in the Supreme Court. And that's a very different environment, obviously, where most of the work is done in writing. And obviously there's maybe an argument. I guess if we get our way, there wouldn't even be an argument. But it's mostly just written briefs and submissions versus a collaborative map drawing process that can be more costly because you're just sitting there for hours and hours and hearing and making decisions.
Thank you. Yes, and the 2010 experience is certainly relevant. So I appreciate you bringing it up. Question 6. The census data will present the Commission with several new variables, including timeline delays, questions of data quality, a new differential privacy policy, and the new inmate reallocation policy. What new litigation risks, if any, do you see for the Commission in these developments?
Yes, I'll take this question, having been intimately involved with our experts in the DVRA defense of the city of Santa Monica. And, regarding delays, our understanding is that these delays are due to the ongoing pandemic, due to the coronavirus. And there's not much, obviously, within the Commission's control to obtain the census data any sooner, or the availability of more accurate or as accurate data. And so the litigation risk in that for the delay issue is likely very minimal. There's not, as I said, there's nothing that the Commission can do to speed up that process. And as long as the Commission proceeds and is ready to proceed once the data is received, it's likely that risk can be mitigated. With regard to the data quality concerns, we understand that census workers and others have raised issues about swapping in data from existing government records as opposed to the gold standard of actually, speaking with, interviewing, or receiving a form back from the individual respondent, as well as allegations of closing cases without visiting the respondent if they did not turn in their form on time. And again, not to belabor the point, but the litigation risk is also minimized in regard to these response issues because there isn't likely the availability of alternative data that is as accurate as the census data. Litigation counsel will, in our role as litigation counsel, we would want to monitor the ongoing investigations and audits concerning the accuracy of the census data to make sure that no additional issues arise. But from what we've seen so far, the litigation risk seems minimal because the census data is really the gold standard. And there's not, another universe of data that the Commission could rely on to be utilized to draw these maps. Regarding differential privacy policy and, the use of noise in the data to anonymize data at every level below the statewide data. Obviously, there's a balancing of privacy concerns versus the accuracy of data here. And I think people understand that that's something, you don't want to be able to determine the exact information about an individual in a given census block in a city. And so that has been introduced into the census data. There are obviously issues with introducing that noise that make the census data on these not the macro level, but the very census block or district level, not completely 100% accurate. However, I think in balancing the privacy concerns versus the accuracy of the data, that decision has been made to, protect the privacy of individuals. And again, the litigation risk there is likely minimized, not only due to the requirement that census data be used, but also the unavailability of alternative data. We would suggest and recommend as litigation counsel that when working with a demographer, and this is something that is a way to minimize litigation risk now, as well as to prepare for responses to any litigation issues raised, is that while working with a demographer, we understand the availability of the 2010 census data. There's both the regular set as well as a set to which differential privacy policy has been applied. And so the demographer can analyze those two data sets and identify any potential issues that might arise in our particular jurisdiction and help make litigation counsel and VRA counsel aware of those issues on the front end so we can be prepared to address them as the maps are being drawn, as opposed to after the fact in litigation. Those issues that have come up or have been identified to date have been, it seems that the differential privacy policy seems to amplify issues in rural areas because of the small population size and having to draw more people from an urban area into the rural area and vice versa, as well as in areas where there are small members of the ethnic community. So those would be issues that we would want to work with a demographer to identify and make sure we can best protect the maps that are being drawn from any influence from that differential privacy policy. We talked a little bit earlier about the new inmate relocation policy, but the notion that inmates be reallocated to their address prior to incarceration as opposed to the location where they're currently being housed in prisons obviously will change the population sizes in some of the more rural areas that are housing these prisons and increase the population size in maybe some more urban areas where those individuals originally resided. And so there might be a challenge from those rural areas saying, we're being underrepresented because we actually are housing these people. And I think to best protect against those challenges, the demographer and VRA counsel will need to take into consideration the accuracy of the data. Do we have the records showing where the inmates resided at the time of incarceration, and making a really clear record about how those decisions are being made if there is an absence of data, or maybe somebody says, well, when I get out, I'm going to a different address. How are those issues being handled? And I think the best way to defend against any potential litigation risk there is to, maintain clear records about what decisions are being made. Also with individuals who may be in prison, incarcerated for life, those individuals also need to be taken into consideration.
Thank you. That's a very detailed response. We'll go to question. Go ahead, someone. No? Okay. We can go to question 7 that we've already begun addressing. Commissioner Sadwani.
I seem to be getting all the softball questions today. So you answered half of this question. After the Arizona 2015 case, we've generally considered independent redistricting commissions to be unconstitutionally safe ground. However, HR 1, which has currently passed in the House of Representatives, if that becomes law, how might it affect the commission?
I'm sorry, I probably stepped on your question a little bit, but anyhow, sorry. The bottom line is, as to the constitutionality of it, largely resolved. HR 1, I've got to admit a little bit of I'm not exactly sure how it affects the body of the redistricting commission. And perhaps I can get back to you on that. You're taking me out of my comfort zone a little bit because I haven't prepared for that question. I mean, I'm familiar with it generally, but I'm not sure how it would affect the body itself, the commission. Mm-hmm. So if you don't mind, I would need to either get back to you on it or maybe go to a next question. I can come back if we have time at the end.
Sure, no problem.
Sure.
I will just note that HR 1 would require the creation of independent redistricting commissions in all 50 states. However, some of the provisions around those commissions would be somewhat different from here in California.
Okay, well, then if it requires change, if the federal legislation requires changes to what California is doing, then we need to look at that. But certainly the congressional willingness to endorse these independent bodies is a good sign, and it ought to tell courts at least where the legislature is leaning.
That's right. I think also, as I frantically scrambled to read the text of HR 1 while we're talking, I think that we all know that HR 1 is very hotly disputed politically, and therefore is, if it passes, almost certainly will be challenged in the courts, and therefore there's a potential avenue for the Supreme Court to say something about many aspects of it, including the redistricting commission aspect of it, which then certainly would provide a possibility for the court to revisit the Arizona case. So certainly something that bears watching. I would say one question, though, is whether those challenges would be resolved prior to the time the commission does its work. And it may well be that the commission just has to proceed as though it has the constitutional authority we all think it does, and see how that litigation pans out. Certainly, if we were selected as your counsel, we would be following that very closely and advising you on it and its impact on you.
Yeah, and I could just add at the end, you'd think, again, you'd hope, and it's hard to predict exactly how things would play out, but you'd think if the commission does its job, and even if there's later a question about whether the commission was properly constituted or whether what should happen next time, the need for finality and certainty for the people of California in terms of where the lines have been drawn should hopefully outweigh any of those concerns, because the reality is you need to do this process. And once those decisions have been made, I mean, that's kind of what happened, I think, last time when there was a referendum process, and the Supreme Court just said, look, they did a really thorough job. They tried their best. They listened to a lot of groups. They made a lot of choices. It's really not for us now to second guess that and to throw our political process into jeopardy for the next 10 years. We'll stick with these lines, and then we can address next time how a newly constituted or differently constituted body might do things.
Thank you.
Okay, we can go to question 8 with Commissioner Toledo.
Thank you, Commissioner Yee. The commission will have to defend being racially conscious in its decision-making as one of our criteria in creating districts.
Okay.
California is also a uniquely diverse state in terms of racial and ethnic minorities. Over the last 10 years, numerous lawsuits have occurred throughout the state under the California Voting Rights Act. How would you defend the constitutionality of a majority, minority, influence, or coalition districts that the commission may have to draw? How would you advise the commission to use or not use partisan election data in pursuing VRA compliance and defending its work? Okay,
well, we'll take this one and there'll be a longer answer, and I don't want to be too glib about the CVRA. We have a ton of experience with the CVRA, including, as Daniel mentioned, filing a Supreme Court brief yesterday that is going to be the definitive, we assume, the definitive ruling on what the CVRA means. But the CVRA, it only applies to at-large election schemes, not district-based election schemes. So there can be, if a district is horribly racially gerrymandered, very, very obviously drawn in a crazy way that looks like a Rorschach test, that is not a CVRA claim, because the CVRA simply does not apply to district-based systems. So that's the easier answer. But Daniel, I'll defer to you on race consciousness in general and the district drawing process.
Yeah, thanks, Con. I think that's right. The CVRA doesn't really move the needle in terms of race consciousness and what the commission can and can't do. The landscape is really much the same as it would have been 10 years ago or really 20 years ago. On the one hand, you can't be excessively race conscious. You can't be that race is the predominant or sole factor motivating the drawing of lines. And that usually shows up, as in the seminal case Shaw versus Reno, in the shape of a district. So if the district is really bizarrely configured, and the only way that a reviewing court can really make sense of it is to say, wow, I think they were really after race here. That's the only way I can really make sense of how you got to this strange shape, this Rorschach ink blot, or whatever you want to call it. So that's one thing you can't do. What you can do, though, is take race into account. It just can't be the predominant factor. But the court has said many times that strict scrutiny is not going to be triggered if you take race into account in this statute or a variety of other statutes and contexts. And so it's perfectly proper to take race into account so long as it's one of many, many factors. And building a really thorough record and narrative of why you drew a district in a particular way, showing that race was not the motivating factor, either explicitly or sort of implicitly, that's really important in making sure that the district would survive scrutiny. So the short answer is the CVRA doesn't really move the needle, and the longer answer is that the law is kind of the same as it was before. You're perfectly within your rights to draw influence districts as you see fit, to draw majority minority districts as you see fit. In some cases, you'll have to draw a majority minority district probably in order to avoid a Section 2 claim, although it's also possible that you could avoid a Section 2 claim by drawing a series of influence districts, as Con mentioned earlier. But the CVRA doesn't really change the answer.
Yeah, and just to follow on, I mean, that is going to be part of the process with your demographer and your VRA council. I assume there will be all sorts of areas in California where you're going to have to check. You're going to have to see, at least roughly, was voting racially polarized? How did it work in the last several elections? And if it was racially polarized, then does Section 2 require us to draw a majority minority district, or does it require something less? And so these are decisions that are going to be part of it. But of course, as Daniel said, they won't be. That's obviously not the only thing you're thinking about when you're drawing these districts. You're thinking about the county lines and city lines. You're thinking about other communities of interest, and so that's really the longer way of putting it. That you need a robust record of all the considerations that went into something, and if race is going to be taken into account, you make sure it's appropriately taken into account in the right scenario, and it is the only thing that you're thinking about when drawing these districts.
Just to amplify the very last part of that question, so do you see any role for the use of partisan election data in pursuing VRA compliance?
Well, you're certainly not supposed to take into account, and you can't take into account incumbency and things like that. So in terms of the where Republicans are going to be and where Democrats are going to be, I assume you're going to hear about it. I assume that groups that are going to talk to you are going to tell you these sorts of things, and so I don't think you can't close your ears. You can't avoid it, but I don't know that should be the criteria on which you draw lines. It oughtn't be. That's really the genesis of this commission, was to be bipartisan and really nonpartisan in terms of where it draws lines. You're not drawing them to benefit or burden any particular group. You're doing it to meet the criteria that the legislature has set out there, which doesn't, expressly does not include incumbency and shouldn't probably include where particular political parties are going to benefit or suffer.
Yeah, and I add something to that, Con, which is that, historically, the Supreme Court has had trouble coming up with judicially manageable standards for partisan gerrymandering claims. And as a consequence, plaintiffs can't really sue on that basis. You can gerrymander away. Of course, that's the whole purpose, as Con just said, of installing an independent redistricting commission that is bipartisan in nature and is trying to do this right, as opposed to doing it for political gain. Then, too, to the extent that H.R. 1 or any other bill is going to create legislatively a partisan gerrymandering claim, it would make sense, I would think, to avoid as much as possible being excessively aware, or perhaps even aware at all, of partisan affiliation, so as to avoid those sorts of claims in the future.
Sure. Just a follow-up question on this piece around the CVRA. And first of all, I wouldn't entirely agree that we're on the same footing in terms of the VRA as we were 10 years ago, given the Shelby County case. However, that deals with, of course, a different component of the VRA. My understanding, and of course you all are the attorneys on the Santa Monica case, so you can please fill me in here, but my understanding of the Santa Monica case is that the issue it has to do with the creation of a district that is less than a majority minority, otherwise known as an influence district or any other terminology that you might want to use. Do you not feel that a ruling on that case could potentially undermine or could be used as evidence to further undermine the Section 2 claims federally?
I can take that.
Let me. Well, yeah. Okay. Take that first. Down. I'll follow up.
Yeah. So first of all, you're right about Shelby County. So that dealt with Section 5, and the reason why you're not going to have to deal with Section 5, at least for the moment, because the Section 4 pre-clearance formula is now toast, right? So that sort of claim for the moment against the handful of California counties that had to get Section 5 pre-clearance, like Kings County, that's no longer an issue. So when I was saying the Federal Voting Rights Act, I was really meaning Section 2, because it's the only part that we really care about that's operative at the moment. On the CVRA, the specific argument in the case is, you're right, is a 30% Latino district required to be drawn or imposed by a court. That's distinct, I think, from what you are doing, commissioners, where you are drawing districts in the first instance. And even if you go back to what the Supreme Court has said, the United States Supreme Court, in cases like Bartlett versus Strickland, it has drawn a distinction between, on the one hand, what a court must impose on a community like the city of Santa Monica, and what a legislative body or an independent redistricting commission may choose to do in the first instance. And the two inquiries are very different. Basically, the court has said there has to be a majority minority district or nothing when it comes to what a court can do. But when it comes to what a legislative body or a redistricting commission can do, it has a much wider range of discretion, and it can choose, as a matter of legislative discretion, to impose influence districts if it wishes. And there may be good reason for that. But what the court has been reluctant to do is to say that you have to change to an influence district. It says that is not a proper Section 2 claim. So I guess when I say that it's much the same as it was 10 years ago in terms of Section 2, I'm really thinking of Bartlett, which itself said exactly that there's a difference between drawing it in the first instance as a matter of legislative choice and imposing it on a city that doesn't want to do it and doesn't have to do it under Section 2. The question for the California Supreme Court is whether the rules are any different under the CVRA. The plaintiffs argue that the court has to impose what amounts to a small influence district of 30% Latino voters. And our argument is that it is not required as a matter of law, and it couldn't be, because that would create all sorts of justiciability and constitutionality problems. So I'll kick it to Con to finish the answer.
Yeah, I mean, and just to follow up on that, an argument in Santa Monica is that the district in Santa Monica, the 30% district, would actually harm Latino voters by essentially, it's a form of packing. It packs as many Latino voters into one district as possible, even though they're only 30% and unlikely to really have meaningful influence over election outcome in a district where you get one winner. And then it cracks, in the terminology of the cases, it cracks the remaining Latino population, which is 2/3 of the population of the city. So the majority of Latinos are going to be put in these districts where they're majority white, and they make up, I think, no more than 14 or 15% of a district. So essentially, it's depriving Latinos of their voting power if you were to switch. So the short answer to your question is that I mean, yes, certainly the cases have given us more guidance. The Section 5 is at least now not a consideration, but the Section 2 cases, there's more information on how those cases work and how a districting body is supposed to use Section 2 or not to draw districts and to do things like that. I think whatever the Supreme Court decides in our Santa Monica case will obviously, it'll tell you something about how the court views influence districts, but it also obviously can't change the ground rules at the Supreme Court level and the 14th Amendment and those sorts of the impediments to influence claims in Section 2 cases will still exist at a federal constitutional level, regardless of what our Supreme Court holds.
Yeah, I'll just add, and I'm not working on the City of Santa Monica case, Commissioner, so I am far away from it as you are. But hearing this discussion, I think that while Con and Daniel, have a view about what the case is and what it's about, our Supreme Court is not shy about saying whatever it thinks and wants to say. about what the law requires, or even maybe ancillary laws require. And so certainly it is possible that the Supreme Court or someone in a concurrence or someone in dissent could say something that has a bearing on what the commission does. And so certainly it's something to be paying attention to.
Although we might not get a ruling in time to matter. We'll see.
Very good. For our last question, and we have about 6 minutes left. Please explain the budget you propose and your ability to work within the billing schedule as provided in the template form by the commission. How would you allocate your time among necessary tasks, including attendance at commission business meetings and input meetings? Where can our staff and your firm work together to constrain costs? Describe generally the work product you will provide and how you will arrive at its proposed cost.
Sure. And as I previewed earlier, there's the planning map drawing stage, and then there's the litigation stage. And so it's, as I said, I think we would really like to and need to be involved in that first stage, but we need to find a way to do it as efficiently as possible. And so we would want to have the more junior members of our team, if there's meeting attendance at lower rates, to be there and to summarize for the rest of us. We would not try to have more than one attorney there. We could even talk about maybe having a flat fee per meeting, which often our clients like to have for some certainty. And so that will be something we're happy to talk about, and having a flat fee that encompasses the planning for the meeting, the attendance in the meeting, and then any internal follow-up and dialogue. But we would need to be involved at that stage. And so that's not a time to save money in our view by not having your litigation counsel involved. It's integral to the ultimate positions we take in litigation to understand why you made choices, and we can be involved and advise. So yes, we would love to have a role at that stage. We would do it as efficiently as possible with lower priced, more junior lawyers, and then ultimately funneling up to the team and letting us make decisions internally. And then as for the litigation, there's nothing that unusual about a writ petition at the Supreme Court. I mean, we do these all the time. It's a fairly constrained amount of work. We could talk about giving you an idea of what that costs. Obviously, you don't know if you're going to get one, you're going to get 10. It's hard to know. And so there's a defined amount of work that goes into preparing a preliminary opposition. And then if the court wants to hear the case on the merits, to a substantive opposition and preparing for argument. So again, we do this all the time. We try to be as efficient as possible. That's really our business model, so that we're not, our clients we're not overstaffing cases. We have the right people at the right billing level do the work, and the more senior lawyers can supervise and ultimately weigh in on strategic decisions. So we could do it hourly. We could do it in a flat fee way, and we're happy to be flexible and talk to the commission if we're selected, or even before that if you want more information.
Okay, very good. We do have a few minutes left. Any questions for us, or any follow-up questions from the commissioners? Anything you'd like to add, Ms. Sauer? I don't think we got to hear from you.
Not particularly, just that I'm, would be thrilled to help with this matter. And thanks so much for the opportunity.
Very good.
Yeah, I don't think we have any. If there's no follow-up questions, we would just, to echo Emily's thought, this is obviously something that happens only once every 10 years. It's such an important process. We were so excited. It was one of the defining moments in Matt and I at my careers. Frankly, 10 years ago, we were senior associates at the time, and 10 years from then seems so far off. And here we are now, and we're both partners at the firm, and we would look forward to leading this matter and leading the commission through many litigation challenges. And it would be a real honor to be involved this time.
I second that completely. And I, not to get too nerdy about it, but I'm a huge fan of this commission. The concept of it, I think it is so important. And I'd just like to thank the three of you and the executive director for taking the time out of your busy lives to serve on it and do this important thing for democracy.
Very good. It's our honor to serve. Anything else from anybody? If not, thank you to the whole team from Gibson Dunn. We certainly appreciate your interest in our work and your time this morning for this interview. Thank you so much.
Thank you.
Thank you.
Thank you.
Thank you.
Okay, commissioners, next interview is at 11:10. So that's about 20 minutes from now. Any thoughts before we go to break?
No, I mean, I think we have to keep the questions as is, but I do think that first question was applicable for yesterday's set. I believe everyone that we're interviewing today, we've already checked of our memberships. But I think we have to keep it now, right?
Yeah.
Since we asked it, I think we have to just keep it.
Right, yeah,
We'll just ask it in brief fashion.
right, exactly.
It's a quick response to.
Indeed.
Okay, well, we can go ahead and take a break now then, and 15 minutes and come back at 11:05. Thank you. We return this morning to our session with the Legal Affairs Committee of the 2020 California Citizens Redistricting Commission. We continue with our interviews this morning for the position of litigation counsel. This hour, we have representatives from the Rennie Law Group, Public Law Group, and here with us also our Executive Director, Alvaro Hernandez, as well as a representative from the State Attorney General's Office, Deborah Yang, who's on audio but not on video. Joining me, I'm Russell Yee, the chair this month of the Legal Affairs Committee. And joining me are the other two members of the committee, Commissioner Sarah Sadwani and Commissioner Pedro Toledo. So welcome. And Mr. Holtzman, why don't I give it to you to introduce your group to us?
Great, thank you. Thank you, first of all, for having us in. We very much appreciate it. So we are the Rennie Public Law Group. We are a primarily a government law firm. That is to say, we primarily represent local governments, cities, counties, special districts, and to some limited extent, nonprofits who are mission driven. Our practice covers government law, including elections law and labor and employment law, as well as kind of pretty much everything, land use, et cetera, that governments, local governments become involved in. A number of us have had significant elections experience, although most of our experience has been, Jenica, for example, was head of the elections team in the San Francisco City Attorney's Office. I worked extensively with the Secretary of State's office over the Gray Davis recall. However, we do not have with us one of our experts in redistricting, Ryan McGinley-Stemple, because of the scheduling issues we weren't able to resolve. I apologize for that. We do have Michael Cohen, however, who is a third-year law student who we have hired, who is deeply steeped in as you're going to see, in this area of law substantively. And we also have a great number of our lawyers have a great deal of appellate experience. I was a clerk for the California Supreme Court. Ryan was a clerk for the California Supreme Court, as well as two other clerkships. We focus very much on people who have clerked. We have almost all of us have many published decisions that we have in our careers. The structure of the proposal would be that the engagement would be co-managed by Jenica Maldonado and Ryan McGinley-Stemple. And unfortunately, again, you're not going to get to see Ryan, and we really apologize for not being able to work out the scheduling problem. So with that, we'll turn it back to you.
Thank you, Mr. Holtzman. And we do apologize for the last minute rescheduling of this interview, which was initially to take place last month. And we understand it was difficult to land on this date. So we appreciate your flexibility, and we understand the difficulties of having the entire team present. So we're thankful to have those of you who are here. And I should mention also, this is being live streamed to the public. We are not taking public comment during this interview, but we will be taking public calls later in the morning. We do have a standard set of questions that we're asking all the candidates, and would like to start with question 1, which Commissioner Sadwani will ask.
Sure. This is a very basic question, but one that we're asking of all of our applicants. Please confirm the California Bar memberships for all of the attorneys who would be on the team, and address any issues that may arise. I'm also curious about the new member who may not actually be bar certified yet.
Yeah, so with the exception of Michael, I checked yesterday at your instructions on the State Bar site, and in fact, all of the other members of the team who we're proposing, that's Linda Ross, Art Hartinger, Jenica, Ryan, and Imran, and myself, are active members of the California State Bar. Michael is a third-year law student, so he is not, but otherwise we're good.
Very good. Question 2, Commissioner Toledo.
Thank you, Mr. Commissioner Yee. The public must have high level of trust and confidence in counsel's ability to provide objective, balanced, nonpartisan advice to the commission. How can you provide that assurance?
So I want to say a couple things about that. First of all, as I mentioned, we are exclusively, well, almost exclusively a firm that works with government. And that means working with commissions and with boards, et cetera. So this is what we do for a living. And that requires, because every board, every commission has different views within it, requires the skill of being fair to all sides and to have credibility with everyone. That's the core of what we do as a firm. So 5 of our 6 partners served in the San Francisco City Attorney's Office at one point or another, including Louise Rennie, who was the city attorney for 16 years. And I was the chief deputy for many of those years as well. So we are, in every situation we go into, we are a nonpartisan, non-biased voice. We often get hired. Louise Rennie's reputation, I don't mean to sort of pat her on the back too much, but Louise Rennie's reputation is somebody who gets hired and brought in very difficult situations, which require credibility. And we do many investigations within boards, et cetera, for example, which are very sensitive. We do a lot of high-profile investigations for exactly that reason, that she has that kind of credibility and firm has that kind of credibility. It's also interesting on the nonpartisan part. So Louise and our office litigated a case called Geary versus Rennie all the way to the U.S. Supreme Court on the issue of nonpartisan elections, and our position was, in essence, to defend nonpartisan elections. Now, this obviously you're dealing with partisan elections, to be clear, but we actually went all the way to the U.S. Supreme Court to try to maintain elections that were by charter nonpartisan, to maintain them in a nonpartisan way. I was also the main outside counsel for the Secretary of State's office in the Gray Davis recall. We got sued by every side. In fact, we had more than 24 lawsuits from both sides, and we prevailed in all of those lawsuits because, again, we called it the way we saw it, and that's what we're used to doing. And that is what our firm is all about. Commissioner Sadwani.
Thank you. May I ask a follow-up question? Given your expertise in local governments and representing commissions and boards, do you have anyone on your team with familiarity or expertise in the Bagley-Keene Act, Transparency Act?
Yes, absolutely. We have a number of people who are very expert in that area. We have, I will say, most of our clients are covered actually by the Brown Act, not by Bagley-Keene, but they're not wildly different, and we do both. So, but I would say a very significant part of our government law practice is around ethics, sunshine, transparency issues. It's a critical, it's a good bit of what we do. I serve, for example, as general counsel to the Moraga-Orinda Fire District, and much of what I do in that, and one of our other lawyers is City Attorney of Corte Madera. So a lot of what that is sunshine, Public Records Act and Brown Act.
I'm also happy just to add for extra benefit. I recently joined the firm from the San Francisco City Attorney's Office, where I was general counsel to the Elections Commission and the Ethics Commission. And I did provide general counsel support to those commissions, including open meetings and open record laws.
Very good. So question 3, given your experience with redistricting, what are common mistakes made by other boards and commissions which result in litigation being brought? And how can we avoid these pitfalls? What actions should the commission take now to mitigate litigation risks in the future?
We're going to turn this question over to Mike.
Sure. So first, just at a very high level, it's important to recognize that there's been a continuous increase in voting litigation since Bush v. Gore, really. And the commission is likely to face quite a few challenges related to its methodology, its process, data, final maps, both for reasons local to California's communities and voting issues that are playing out on the national level. So with that said, other redistricting boards and commissions commonly make a series of mistakes which result in litigation being brought. And I'll talk about that in quite a high degree of detail, so please do interrupt me. Failing to properly identify areas protected by the Voting Rights Act early in the redistricting process is a common issue. Without a clear sense of VRA districts, efforts to meet other redistricting criteria might need to lead to the creation of districts that actually dilute the minority vote. So districts eligible for VRA protection should be identified early on and drafted first so that they're not compromised later in the map drawing process by efforts to meet other redistricting criteria. So what the commission can start doing now is immediately start gathering data that will establish early in the process any areas that merit VRA protection. That includes exploring areas of high minority growth, conducting a statewide racially polarized voting analysis, collecting information on the history of voting discrimination in the state, and collecting other social and economic data. That will allow the commission also to then retain outside counsel to provide separate and independent opinion about regions of the state that are eligible for VRA protection, which can later be used to justify race-conscious redistricting in court. That's a common mistake, is having internal counsel, the same counsel tasked with advocating for the commission, certifying areas meriting VRA protection. That's just not as convincing to a court. Another common mistake is setting mechanical racial targets for districts with inadequate evidence in the redistricting record to establish a credible fear of VRA Section 2 liability arising from the target district. We saw that play out dramatically in 2017 in the Supreme Court. But Supreme Court precedent pretty clearly indicates that those racial targets are a straightforward signal of racial motive in redistricting. And if the commission is going to set those targets, they have to first establish that the target district merits VRA protection by finding that the district's minority community meets the Jingles preconditions and the VRA's totality of the circumstances test. And that relates back to the necessity of conducting statewide VRA-related analyses early in the process. Another common mistake is failing to record and be responsive to public comment in the drafting process, and especially failing to listen to minority community members when they raise issues concerning electing their candidate of choice with proposed maps. Public input, as this commission knows, is a critical source of key information, and it's really important that the commission feels heard. It's part of the commission's mission. It can be difficult to weigh public input because of its sheer volume, and so developing a system to collect and organize this information will help the commission protect its maps from legal challenges. Specifically, the commission should develop a systematic method for identifying the specific testimony and deliberation relied upon in the creation of each district, which will help the public feel heard and help the commission defend its districts in court. Another common mistake is related to this is failing to give essential tools to the public to enable participation in the mapping process. It's our view that the commission should do everything it can to promote transparency and public participation, including giving the public access to shapefiles for draft maps. Situating the public to best provide effective testimony and proposed maps is ultimately to the public's and the commission's advantage. So in addition to that list, which I've already mentioned, there are quite a few other steps the commission can take now to mitigate future litigation risk. One big one is continuing to train commissioners on the Voting Rights Act, communities of interest, and racially polarized voting. It's our understanding that Justin Levitt and Chad Dunn and Matt Barretto, who I've worked with, have already provided some training to the commission, but additional training, particularly in the application of the Voting Rights Act, will help the commission remain VRA minded moving forward and also further the purposes of Prop 11. The commission should also decide whether they want to use existing maps as a starting point or start fresh. So this is a procedural question, but it has legal implications for minority electoral power in the new maps for a variety of reasons. Starting with existing maps could help leverage retrogression standards that may exist under federal law even after Shelby County, or future retrogression standards enshrined in HR 4 if it will apply to this redistricting round, but I don't think anyone is holding their breath for that. The commission can also begin collecting quantitative and qualitative information related to defining communities of interest and supplementary boundary files and other data that can help justify breaking up those communities of interest, like city and county splits. So last decade, it's our understanding that the commission determined COIs exclusively from public input instead of supplementing public input with other types of data. But the public is sensitive about maintaining communities of interest, as this commission knows, and the commission can take additional steps now to help ensure that they're reflected in the redistricting process. Additionally, the commission can continue to widely advertise meetings in all the appropriate languages, both on traditional platforms and on social media, so that the public is guaranteed a chance to participate in the process. The commission can also settle on standards for how far districts can deviate from perfect population equality early in the process. As you know, state assembly and Senate districts are only required to be substantially equal, and that creates ambiguity for map drawers. Last decade, it's our understanding that the commission adopted different standards for deviation at different stages of the process, which drags out the drafting process and potentially creates liability. To help protect the commission's maps from challenges this round based on population inequalities, the commission should establish early how much deviation it will tolerate in its standard and VRA districts. Finally, the commission should allocate time and budget in the process to allow for effective tracking of map revisions. So last decade's commission reportedly struggled with this. It's quite a task, but draft maps are likely to appear in litigation, and they can be used to explain or justify features of final maps. So I'll leave things there in the interest of time, because I know that's a lot, but I'll end by noting that it's our responsibility as litigation counsel to make sure that the commission is preparing for litigation immediately and has an eye toward it at all times, especially as it strategizes to best meet its mandate to remain transparent, promote public participation, and redistrict fairly.
Thank you. That was a lot, but all relevant. I'm wondering, let's see, I didn't quite follow early in your response, your thoughts about using identical counsel for two different stages of the work and that being less persuasive. Could you clarify that a bit?
Sure. So essentially, if the same counsel that is tasked with advocating for the commission in court is also the counsel that early certifies the districts that are eligible for VRA protection, it appears less convincing because obviously that counsel is biased toward defending the commission. So having outside and independent counsel certify those districts early in the process will make sure that at least a third set of eyes has been on those districts, and a court can reference that certification in determining whether there was a credible fear of Voting Rights Act Section 2 liability in using race-conscious redistricting. Does that answer your question?
It does. Thank you so much. Okay, we can go to question 4, and Commissioner Sadwani.
Sure, thank you. And thank you, Michael, for that, very complete response. That was great. This question is actually along similar lines. If the commission successfully files its maps on time and in good faith compliance with its constitutional requirements, on what basis are its maps most likely to be legally challenged?
Sure, so I'll be taking this as well if it's acceptable to the commissioners.
Sure.
Aside from denial of access claims, which aren't covered by your question, most redistricting litigation in the coming decade will continue to flow from Voting Rights Act Section 2. As the commission knows, those claims challenge the dilution of the racial minority vote, either by dispersing or cracking minority voters among districts so that they're ineffective as a voting bloc, or concentrating or packing minority voters in district so that they constitute an excessive majority, which dilutes the minority vote in adjacent districts. So some of those claims might actually arise after minority communities that are currently teetering on the brink of meeting the conditions for VRA Section 2 protection grow beyond their present size, making a Section 2 challenge available to them. Other common challenges will allege an improper use of racial data in the redistricting process. So racial gerrymandering claims are primarily based on the 14th Amendment's Equal Protection Clause, as this commission knows, which prohibits governments from passing laws that differentiate between persons on the basis of race without a compelling justification. Those are sometimes called Shaw-type claims, and they involve allegations that race was a predominant motive in drawing districts. Similar challenges might also be available under the California Constitution's Equal Protection Clause. There may be litigation this round related to alternative maps via referendum, though that played out quite dramatically last round, and I suspect that won't arise this round quite as prominently. These are likely to be the primary legal challenges to the commission maps, but they're far from the only legal challenges that the commission might confront, and we can talk about some of those other challenges later on.
Thank you. We'll go to question 5 and Commissioner Toledo.
So thank you, Commissioner Yee. How would you view your role when working with the VRA Act Council retained by the Commission in avoiding potential litigation as well as defending the Commission during litigation? How do you envision your role in working with the CRC line drawer and with other CRC staff?
I'll answer this question. So our firm is very adept at working sort of on both sides of the aisle, so to speak. We have a lot of experience providing government entities, commissions, with advice in that general counsel capacity, but then also, when appropriate, switching sides and defending those decisions in court. And I can speak to that. I have personal experience with that in the election space. As I mentioned, I served as general counsel to the Elections Commission and the Department of Elections. And in that role, I actually served as general counsel to a specific body called the Ballot Simplification Committee, which is a group of lay people in San Francisco who have expertise in journalism or other writing areas, who draft our ballot digests in San Francisco. And so I would advise that commission, I would prepare the drafts, I would advise them about open meetings issues, I would advise them about the legal implications that the changes to the digest were being made in real time. And then they would vote and approve those various digests after taking public comment. And so after going through that exercise, when those measures were then later challenged in court, I would turn around and then defend the measure in court and make sure that the measure was upheld in favor of what the voters had intended, in some cases post-election. So we have a lot of experience at large in the firm in that area, but I personally have experience in that role. And from that vantage point, I can say that I see that I think it's really valuable to have people that know how to do both advice and litigation in this space, because having someone that's just a litigator doesn't always necessarily appreciate the nuance of how issues play out in the advice context, right? So they don't have experience sort of in real time preparing the government decision and helping the stakeholders and the commissioners in reaching that decision. And so they can't as easily anticipate what might happen when we get to court. And so when you retain the Rennie Public Law Group, you have the benefit of that vantage point. People in our firm understand sort of where things can go. In this particular context, we would intend to work with the VRA Council as collaboratively as you all would permit us, of course, being extremely cost conscious in doing so. We would want to participate and consider what sort of litigation risks could arise from decisions that are being made on the front end. And I think a lot of that is probably making sure that we're getting the necessary data collected and that those decisions are being reflected properly in the maps as they're being drawn. And so we also have a lot of experience working with area experts, working with the firms that you retain that actually do the map drawing. We have experience in that area as well. And so we're facile and able to communicate with those people. And so we would work collaboratively, not only with all of you, but with the staff at CRC to really make sure that we were issue spotting things for you. Well, if we make that decision, there's a possibility that we could face litigation on this in the future on this issue. And we would always vest that decision to you. We see you, you're the client, you're the decision maker. It's just our job to empower you with the information. And then it would also ensure that once when and if we are defending litigation at the back end, that we personally observed what was happening, so we would have a better understanding of how issues actually sort of materialized, and would definitely, in my opinion, help our defense of any claims that might be brought against the commission.
Thank you. We'll go to question 6. This has to do with census. The census data will present the commission with several new variables, including timeline delays, questions of data quality, a new differential privacy policy, and the new inmate reallocation policy. What new litigation risks, if any, do you see for the commission in these developments?
So Michael and Ryan wrote an article on the first part of this, so we're going to turn this over to Michael as well.
Yeah, absolutely. So yeah, Ryan McGinley-Stemple and I, we authored a piece in Public CEO, and we attached that to the RFP response. As this commission knows, in July, the California Supreme Court ordered that the constitutional and statutory deadlines for statewide redistricting be pushed back by 4 months to account for the anticipated delays in the census data. And the order also accounted for potential additional delays by allowing deadlines to be extended by the number of days of any additional delay. Those and deadlines for independent redistricting commissions in HR 1 won't apply because of the exemption for commissions like California's in the statute. But California's relatively slow population growth over the last decade means it may lose a congressional seat or two. The latest delay in census data will require the California Supreme Court likely to push back the commission's December 15th deadline even more. Otherwise, the commission would have just 2.5 months to redistrict. But that could collide with the opening of the candidate filing period on February 14th, 2022. The filing deadline could probably be pushed back by a week or two, but the certified list of candidates for voter-nominated offices needs to go out by the March 31st deadline so that election officials can get the ball rolling. So there might be some litigation risk related to districts that disappear days before or even after the filing deadline. That might seem unlikely to the commission, but this is just to say that the commission and litigation counsel should continuously keep an eye on upcoming deadlines, especially in light of new delays. And while the commission still has ample time now and generally isn't responsible for the delays in the process could create serious problems. As to the data quality, it's not yet clear how the data will perform against measures for accuracy in terms of omissions and erroneous enumerations in coverage areas, but early coverage quality indicators do suggest some serious issues. Just as with changes to the data related to the new privacy policies, which I'll speak to next, there might be some issues related to whether the data will hold up in court when compared against data which predicts population characteristics based on statistical modeling. But nevertheless, today, census data is still the gold standard, and the commission is required to use it. And ultimately, plaintiffs will carry the burden of proving that more accurate data is available, so the commission may be on safe ground here. As to the new privacy policy, it's our understanding that the use of differential privacy means that reported data won't be the same as the raw data. While total population in each state will be as enumerated, all other levels of geography from congressional districts down to townships and census blocks could have some variance from the raw data, and that may raise some issues for racial block voting analyses. The differential privacy has implications for smaller subpopulations, so it could introduce substantial amounts of noise in the data for rural populations. Specifically, rural areas are likely to show increases in population, and urban areas may show decreases in population. And smaller subpopulations, like specific racial groups, will probably be affected more than larger racial or ethnic groups. There might be some new litigation risk here related to the accuracy of population data below the state level, just as with the data quality issue. And the commission needs to be able to accurately establish population equality between districts and determine what is an effective minority district under the VRA. It's not entirely clear that the census data will be satisfactory to determine whether a plan actually meets the SIMS one person, one vote principle in court. But as I mentioned, plaintiffs will bear the burden of showing otherwise, and it seems unlikely that sort of challenge would be successful. Ultimately, it may be to the commission's benefit to work with the demographer to identify areas that may give rise to issues, and that can put the commission on notice early in the process. As to the new inmate reallocation policy, the election code requires reallocating prisoners from the prison location to their residence prior to incarceration. Those who are an in-state resident prior to incarceration are counted in their last known residence as district population, and then those who are out-of-state residents prior to incarceration or whose status is unknown are excluded from all district populations. that sort of policy requires a significant amount of work and collaboration between agencies and authorities at the state and local level, and issues may arise there, sort of logistically and procedurally. The state's census blocks, as reported by the Census Bureau, also have to be updated based on this new data in order to reflect the correct populations pursuant to the state's new apportionment procedures. So there may be some new litigation risk here related to improper allocation, especially if it affects analysis of effective majority minority districts under the Voting Rights Act. And there may also be additional litigation risk related to non-residents prior to incarceration not being counted in any district, given that they would be left out of their out-of-state district as well, especially if they're incarcerated for life. Again, I want to be conscientious about time here, but those are some of the new litigation risks this round.
Thank you. Yeah, I think the statewide database actually reported that inmates without a last known address will be assigned randomly to districts, but I'm not sure that's a done deal yet. So we can all keep tracking that. Question 7, Commissioner Sadwani.
Sure, thank you. After Arizona v. Arizona in 2015, we've generally considered independent redistricting commissions to be unconstitutionally safe ground. If HR 1, however, becomes law, how might it affect the commission?
I'm going to take this question. So if HR 1 does in fact pass through the Senate, I think that that's actually a pretty stabilizing, positive thing for the commission, right? So if HR 1 becomes the law, then commissions like the one we have in California will become recognized legally across the country. As you all likely know, our setup for the commission here in California was used as a framework for the independent redistricting commissions in HR 1. And so HR 1 expressly recognizes that independent redistricting commissions such as ours are legal and valid under HR 1. And in fact, to the extent that they predate HR 1 like ours does, they can maintain their structure and continue to operate as they exist, provided that they meet certain criteria that are set forth in HR 1. So there are 7 different criteria. And generally what those relate to is ensuring that there's a public and open application process, that there's the people who are on the commission are not already serving in government or have some sort of political appointment to the process, that the members of the commission don't have conflicts of interest that would jeopardize their ability to act fairly on the commission, that the members of the commission reflect multiple political parties in terms of their political affiliations, and that the members of the commission exercise their duties in a way that maintains communities of interest and does not draw maps in a way that would favor one political party over another, that public input is maintained and prioritized in the highest degree possible, and that the decisions of the commission are made based on not only just a majority of the commission, but based on sort of a broad, it's called a broad base of approval. And so we see obviously the passage of HR 1 as overall positive for this commission. It would provide a level of stability to the operating scheme that we've all come to depend on and trust in light of Prop 11. And so it would be a good thing. And we're hopeful that it happens for that particular purpose.
Very good. We'll go to question 8 with Commissioner Toledo.
Thank you. The commission will have, and this is a long question, the commission will have to defend being racially conscious in its decision-making as one of our criteria in creating districts. California is also a uniquely diverse state in terms of racial and ethnic minorities. Over the last 10 years, numerous lawsuits have occurred throughout the state under the California Voting Rights Act. How would you defend the constitutionality of majority minority influence or coalition districts that the commission may have to draw? How would you advise the commission to use or not use partisan election data in pursuing VRA compliance and defending its work?
I'm going to take this question as well. So the first thing I might just point out is that the CVRA and the litigation that's resulted from the CVRA is insightful to the extent that it demonstrates how the California Supreme Court might act on on a case that comes from this commission before it, but it's not binding per se, because we are not subject to the CVRA. That applies to localities, right? And we're acting at the state level, and so we are subject to the Federal Voting Rights Act. And so it's informative, but it's not completely dispositive. So one thing, though, that is interesting and that probably should be considered, and the commission should keep an eye on, is that a lot of racially polarized data and information about communities that have experienced that have sort of come forth from this litigation. And so the commission should be particularly attuned to that and really should take a close eye at the districts in the past that have been affected by CVRA litigation, particularly ones that were previously covered by Section 5 of the VRA. So that would be one recommendation we would make. In defending majority and minority districts, the VRA still requires that we demonstrate a credible fear that Section 2 liability under the VRA may occur. And so, that's where obviously litigation counsel comes in, and this is really where it's helpful for us to work on the front end with your general counsel to make sure that what we are doing truly is narrowly tailored and complying with the compelling interest required to demonstrate that we are following Section 2 of the VRA. And so we can really show, if we're involved in the front end, we can help develop that compelling interest to make the map as defensible as possible. So to the extent that we're taking account of racial data, we're doing so in a way that's constitutionally justified. In terms of coalition districts and influence districts, those have not been as acutely recognized, as you know, by the US Supreme Court. That's not like ironclad law, particularly in the case of influence district. We should assume that it's highly unlikely that that would be recognized at the federal level. And so that said, those are not as clear. But obviously in California, coalition districts and influence districts are going to be something that the stakeholders are going to have a really strong interest in. So that's going to be a tension that the commission is going to be faced with. And I think that the best approach there is to deal with that on a case-by-case basis. As you can tell, these things really are, it's going to depend on what's in our record. It's going to be essential that we demonstrate that we have the right circumstantial or direct evidence that sort of influenced our decisions in one way or the other. And frankly, what you all say in these meetings could be quite dispositive in determining the course of litigation. And so if we have provided all of you or us or someone else have provided you with adequate training of what is required under these laws, sort of at the front end, that you are informed and empowered with that information, that when we are drawing lines for particular districts where we think that there's a high probability of litigation, we'll be able to properly inform you that, okay, for this particular kind of district, these are the sort of criterion that we should consider, and this amount of consideration of race is or is not appropriate, and this is where sensitivity might lie. And that's where, great legal counsel is critical and really can make sure that all the hard work that you're doing is upheld and isn't undermined by a subsequent legal decision. In terms of use of partisan data, we would advise against it. If HR 1 is actually going to, if it's passed, will expressly prohibit the use of partisan data. And so I think that's the direction that it's probably going. And given the complexities around that, it's just sort of advisable to not use it. And, these are the types of conversations we would welcome and hope that we can have with you further in the future on a case-by-case basis.
Michael, let me just quickly turn to you on this question about the possibility that there is a non-retrogression standard in Section 2.
Sure. So after Shelby County, there's a big question as to whether retrogressing minority electoral power is permissible under the Voting Rights Act. Even though we've lost the pre-clearance regime under Section 5, it nevertheless remains the case that there's a very strong legal argument that Section 2 contains its own non-retrogression standard. And so particularly if this commission decides to start the redistricting process with existing maps, it might defend its coalition influence districts, which may be on slightly weaker legal footing, by pointing to the mandate not to retrogress minority electoral power.
Thank you. For the last question, please explain the budget you propose and your ability to work within the billing schedule as provided in the template form by the commission. How would you allocate your time among the necessary tasks, including attendance at commission business meetings and input meetings? Where can our staff and your firm work together to constrain costs? Describe generally the work product you will provide and how you arrive at its proposed costs.
So honestly, a lot of this is up to you about how you want to work with your litigation counsel and how much you want to bring your litigation counsel in, given that you also have VRA counsel. You know, and we are in every place we go, there is a difference in what staff is capable of doing, and for that matter, what a commission is capable of doing, or a board, and not. One of the things that we specialize in is a lot of the work we do is data rich, information, you know, issues or very complex issues, et cetera. And we are very used to not only supplying, you know, work of lawyers, but work of experts who we employ through the firm or not, depending. So the amount that we, and of course, you're going to have a lot of experts on staffs to work with. So we have situations where our clients are really quite self-sufficient, and we take just an advisory role and kind of sit back. And we are very, very aware of and alert to the concern about cost, of course. And you know, in the best of all worlds, every litigator wants to have had a hand in the decisions they're having to defend, right? Because you know, there is kind of nothing worse than having a decision you disagree with and you would have made differently. You know, but that said, we're very sensitive to the cost issue. One of the things about, you know, our firm, because we work in the public sector, is our rates reflect the fact that there's a great deal of public attention on the cost of lawyers. I mean, as much as we are lawyers and don't apologize for it, the public, as you probably are aware, doesn't always love lawyers, doesn't like lawyers' rates very much, and they're often a flashpoint. And that's one of the reasons why we, in coming to this firm and creating this firm and leaving big firms, which many of us did, you know, decided that we would be in a situation where we would charge significantly less than big firms do, and hopefully do you know, as good or better job than those firms doing what we do. We're public interest oriented. So I do want to say how much we plug in really turns on budget and how much you want us to plug in, and how much you want us to bring to the table. So we are, as far as the billing, I read the billing guidelines, which, you know, look basically like what we comply with anyway. We are not a firm that has a lot of hidden charges. We don't charge for faxes. We never did. Copying, except in, you know, very large, you know, when that kind of thing, we don't charge for that. You know, so we are, you know, what you see is what you get as far as our rates go. And we provided you, you know, what those rates are. Obviously, at this point, we don't know. I looked at what the costs were last round. We have no idea, obviously, this round, what you're going to be facing. And I have to say in all candor that even with lower rates, that if you end up at the U.S. Supreme Court, you know, it's going to drive expense, obviously. But, you know, there are a few things there that are in the guidelines that are really not quite written for this precise task. For example, you know, one lawyer at each appearance. Well, you know, the kinds of appearances that you would be making in the Cal Supreme Court, for example, you know, are probably going to justify two lawyers at that hearing. So, you know, to be perfectly candid, there are a few places where I think the guidelines probably, and again, the guidelines allow for that, to be clear, but I just, you know, heads up on that, obviously, that, you know, these are very, very, very important cases, and it's a question of not what's good for our firm, but what's good for the client.
Thank you. We have up to 10 minutes still. Do you have any questions for us, or do commissioners have any follow-up questions?
Janica, you want to? Well, I'm sorry. Let me ask the commissioners first. I apologize.
No. Any questions for us?
Janica, Michael?
Yeah, so we understand that the commission has already begun the educational component of its public engagement program. I'm curious how expansive that program will be relative to last decade's education and outreach efforts.
Excellent question. We have begun our educational phase of our work. As it happens, and now especially with the census delays, it looks like we will have over double the time that the 2010 Commission had to do its work. The 2010 Commission actually had no separate educational phase. They ended up with 34 or so statewide public input meetings, which also served as their education phase. So we're doing it in two different stages, going out once for education and mostly using a standard scripted PowerPoint-driven presentation for that. And then we'll be going out again for the actual public input, line drawing, draft maps, and all that. So yeah, two different phases of our work.
I guess I have a question. I mean, what, if any of you are willing to share, what, how do you envision the role of litigation counsel in terms of the level of interaction that they will have directly with the commission or with VRA counsel at this stage? And I appreciate that this is a developing process and that might change, but if you have thoughts about that, I'd be curious.
Commissioners?
I'll just say we haven't had that full conversation with the full commission. However, as we see it, I think as we've devised this process to create both a space for a VRA council, given the very unique nature of the VRA and the very specific process that entails and requires. Litigation, we, as our questions, I hope, acknowledged, can take many forms, much beyond only concerns of the VRA. And so I think that there is a very real opportunity for our litigation team to engage with the commission closely from here on out. However, of course, being cost conscious, because ultimately we are working with taxpayer dollars, and we take that consideration very, very seriously.
Thank you. I appreciate that.
Mm-hmm.
For whatever it's worth, I mean, obviously we would welcome the opportunity to be more involved rather than less involved, I guess, if there's a bias here.
Sure.
But I just want to be respectful of the fact that this is very much a commission decision and not be presumptuous.
Sure.
Thank you for the opportunity to be interviewed. We were really excited to be selected for consideration. And as you can, I hope you can tell, we're very enthusiastic about the subject matter. And thankfully, we do have a sort of pseudo area expert in Michael, but to the extent that myself and Ryan admittedly has also very admirable level of knowledge in this area. And so to the extent that the rest of us can get up to speed and use our litigation skills also at the appellate level as well. I do have a substantial amount of appellate experience, and I did extern for Justice Kennard on the Supreme Court. So I have some familiarity about the court and would welcome the opportunity to resume litigating there, particularly on such an important matter.
Thank you. Yes, your enthusiasm certainly comes across, and we do certainly appreciate your interest in serving and possibly serving the commission, and your presence here today, especially on a rescheduled interview. And so all the best to you. If no other further questions, all the best to you, Michael, and you're wrapping up law school and flying through the bar exam, I'm sure.
Yes, I was going to say, I hope that there's a position for you waiting at the Rennie Law Group.
There is. I mean, he will be joining us in the fall. I should probably make that clear. Yeah.
Very good.
By the time if we were to have this matter and actually working on it, Michael would be fully up to board and would be working for us full time and would be fully immersed in the project. So.
Yeah, we have 1 minute. I'll say, I mean, so the way Michael came to us, we do a fellowship program every summer and to steep law students in public policy issues and a lot of the difficult issues that we face. Michael was in our inaugural class of the fellowship program, and we gave him an offer on the spot. This is long before we knew any of this was happening. So we did not bring him on just for this purpose. In fact, we had no idea this was even even an issue. We were just very, very impressed with him, and he's also got spectacular grades, by the way, et cetera, as you might imagine from his demeanor. So anyway.
And I will be passing the bar this summer.
Yeah. And now you have on public record a job offer there, Mike. So.
Exactly.
Well, very good. Thank you so much to the team, and thank you for your time and interest.
Thank you.
Thank you.
Okay, commissioners. Well, that actually wrapped up a bit early. Special thanks to our ASL team that you really had a lot to keep up with on all of these, but especially this one. And you do so with a smile on your faces. I appreciate it. Okay, any thoughts before we go to lunch? If not, let's see. Our next interview is at 1:05. So let's take an hour and 5 minutes for lunch and come back at 1 o'clock.
Thank you.
Thank you. Welcome back. We are the 2020 California Citizens Redistricting Commission Legal Affairs Committee. And we're on to our final interview for this series of meetings. 6 interviews, 3 for VRA Counsel, 3 for Litigation Counsel. And we now have returning to us the firm of Strumwasser Witcher, plus Mr. David Becker. They've applied to both positions. And so this will be their interview for the Litigation Counsel. Once again, we have Director Alvaro Hernandez with us, as well as a representative of the State District Attorney's Office, Deborah Yang, who's with us via audio, not video. With me once again are my fellow commissioners, Sarah Sadwani and Pedro Toledo, and I am Russell Yee, this month's chair for the Legal Affairs Committee, and we are 3 of the 14 commissioners serving this round. Once again, we are streaming this to the public, but will not be taking public comment. We will open the public comment line shortly after the end of this interview, and it will remain open for the rest of the afternoon's deliberations. We also, as always, invite written comments. Any comments we receive will be posted in the public comments section on our website. Okay, well, we welcome back some of the same folks we met yesterday with one change. So why don't I turn it over to Mr. Witcher to reintroduce his team.
Sure, thanks very much. And thank you again for the opportunity to be before you. It's going to be a little awkward, I guess, because there's some overlap between yesterday's interview and today's. And while we don't want to bore you with repetition, I think there are some new people who may be attending as well. So we will probably repeat much of what we did, but try and put a little slightly different emphasis, because today is a little different focus, dealing with the litigation aspects of it in general, rather than those specific issues relating to the Voting Rights Act compliance. And so first I want to introduce the team, and then those who are here will say a few words after me. As before, we have David Becker and Andre Orden, whom you did meet yesterday. And then the new addition is Michael Strumwasser, one of the co-founders of the firm with me back 30 years ago. And it makes sense for the two of us to be here, because in a way, this really is the bread and butter of what our firm does, representing public agencies on complex issues of public policy. And it was the reason we formed the firm 30 years ago, when the two of us came out of the Attorney General's office and then immediately began representing the new insurance commissioner, who had been elected pursuant to a voter enacted initiative, Proposition 103, which immediately led us to have to work with the new commissioner in trying to implement that, defend that legality of the commissioner's program against a number of different legal challenges in different courts from the insurance industry that was resisting it. So this type of litigation is exactly what we like to do and what we've done, as I say, for the past 30 years together as a firm, and even beyond that in our other capacities. I must admit, we were a bit intimidated by the request for information when it asked us to please list the 10 most recent California Supreme Court cases that we had argued. I think many lawyers would consider one argument before the Supreme Court to be the highlight of a career and call it a day at that. So we did have to go back a little farther than what most people would consider recent. But I think we do display that, in fact, we have significant experience in exactly that area, and potentially as much as any other firm in the state, if not more so. I've been counsel in argument in 4 cases, 5 actually are going back to before the firm. My partner Michael has been in several. Andrea has been in several. It's really a familiar terrain for us, and a lot of what we do in terms of representing agencies is in preparation for the possibility that we will have to be there again and defend their work. And so with that preparatory comment, let me turn it over to the new addition first, my partner Michael Stromwasser, whose real area of expertise in many ways is administrative law. He's literally written a book on administrative law and will be very helpful in preparing the record that would be appropriate to proceed for the commission. So Michael, why don't you take it from there? And then David and Andrea will reintroduce themselves as well. Mute. Michael, mute. You know, this is actually a pleasure. We don't get to mute him very often, so.
Yeah, it's Fred's preferred state for my microphone. Mr. Chairman and Commissioners, thank you very much. It is an honor for us to be here today, and it is a particular honor to be considered for this truly historic work that your commission does. As Fred said, we started Stromwasser-Wucher in 1991. I've only had 2 jobs in my life. I was in the Attorney General's office for 17.5 years. The last 8 of them with Andrea, and the last few of them with Fred, where we did handled some of the most important cases that were brought in that period. And then in 1991, we started Stromwasser-Wucher when it was literally Stromwasser and Wucher and an office manager, and it was it was an open question whether one could build a practice around public interest and public representation litigation, and so far it's working. I don't want to jinx it or anything, but so far it seems to be possible. My contribution has largely been in the area of governmental and administrative law, and in particular with respect to the regulation of financial and regulated utilities and insurance companies and others. And it's a specialty which has brought me into regular contact with expertise in things like econ, statistics, and data processing. It's enabled me to bring to bear a facility with numbers. I've often said that a lawyer who can do high school algebra actually can be a very dangerous person, and it is really true that if you're not afraid of numbers, you can really do some good work. And I have specialized in administrative law. I am a co-author of the Writer Guide on California Administrative Law, and I have regularly do CLE lectures on that. Andrea and I have a roadshow we do about compliance with the Brown and Bagley-Keene Acts, and so it is an area in which I'm comfortable and have a reputation. I am honored to be here, and I'm honored to put our firm's skills at your disposal. Thank you.
Also on mute.
Unmute. In the great tradition. I was, as we've talked about before, a government lawyer for more than 25 years. I was the first United States attorney to be both a woman and a woman of color. I'm Latina from my mom's side, Hermosillo, Mexico, and my father from England or Ireland, whatever story he liked to tell. And I have been, you have just heard, in the State Attorney General's office twice. First, where I did go to the California Supreme Court 4 times, and then returned as chief assistant with responsibilities for the Civil Rights Division and the Environmental and Consumer and Antitrust Division, where we did go to the Supreme Court and to the United States Supreme Court. I finished my public career after a stop out for 19 years at Morgan Lewis as a partner and then senior counsel. Finished my public career, as we started to talk about last time, at the county counsel's office in Los Angeles County with the 10 million folks. And just fortuitously, I did come in 2010. And in 2010, we began within months preparing for the redistricting issues. Of course, it was a very different time. It was not an independent commission. It was lines drawn by 5, as we talked about, allegedly nonpartisan, but very independent 5 commissioners. What we did was first assign most of our initial work to some of our most senior lawyers in the office, some who had even been around at the Garza time, and many of you know that was the case which found that Los Angeles County had indeed discriminated in the past. So this was at a time when all restrictions were off, but necessary to comply with the law. So first it was our staff people in the CEO's office and in my office, putting together the public outreach, working on finding experts, etc. As time went on, we interviewed some of the best lawyers in Los Angeles for the job of outside counsel who led us forward. So we had a team of both in-house and outside lawyers working on it. Made the newspapers. The final decision on the case came after 1,700 people were in our audience at the Board of Supervisors. 3 competing plans, one by the Boundary Committee, one supported by Supervisor Gloria Molina. And eventually, at the end of the day, with a lot of bargaining among the supervisors, the Boundary Commission Committee went forward. And although it was always anticipated that there would be litigation, there wasn't. And it was the opinion of the county council and of our outside lawyers that either of the 2 plans would pass scrutiny. Whether it was because that really was accurate or because there wasn't ability for anyone to sue at that time, we didn't know, but we felt we had done our job with an enormous amount of public outreach, an enormous amount of experts, and some of the finest experts on both sides.
It's my turn. I won't rehash a lot of the things I said yesterday where I went into a little more detail, although I'm happy to answer any questions about my background and qualifications if we have time, especially given that I know I was a recent addition to the team. So I really welcome any questions that anyone might have, given that you probably had limited time to review my background. But I'm David Becker. I'm a Californian. I'm a California lawyer. I just happen to be in DC, where I have been stuck for over 22 years now. I've been working in elections for over 2 decades. The reason I moved to DC after I'd been practicing law in Los Angeles for several years with 2 different firms, where I practiced both in front of state and federal courts, litigating as a litigator. I moved to the Department of Justice, where I began 7 years working under the Clinton and Bush administrations in the voting section of the Justice Department, litigating a variety of voting rights cases, probably most notably many redistricting cases. I probably reviewed at least 2 dozen. I looked at probably about a half a dozen alone in California, including 2 that were litigated here in California, and had a case that went all the way up to the United States Supreme Court, Georgia versus Ashcroft, which was decided in 2003. Since that time, I've stayed in elections. I work. I've now founded my own nonprofit, the Center for Election Innovation and Research, which has grown to about 10 employees, and works all over the country with election officials of both sides. It's really important that kind of a core element of our work is working with election officials and others from all across the political spectrum, working with election data in particular. I think we have a particular expertise in that, and I do individually as well. So with that, I'll leave it and happy to answer any further questions.
And let me just throw in here, there's just the 4 of us here before you today. There are other members of the team. We didn't want the boxes to have to be so small that nobody could be seen, so we asked them to stay away for a moment. But we anticipate that the speed and potentially the breadth of the litigation is obviously going to need to put together a team of people, a team of attorneys, and we have a strong bench at Sturmos, which are 2 attorneys in particular that we put in our written materials and told you about. Dale Larson, one of the partners, who's got extensive litigation experience, and the newest member of the firm, but by no means a new attorney. He's 4 or 5 years practice and 2 judicial clerkships. Salvador Perez are both members of this team, and would be actively involved in anything that we did for the commission.
Very good. Thank you. And we'll proceed to our standard questions. And I realize some of these will indeed overlap with yesterday's discussion, but we'll just ignore that for now and approach this as a fresh encounter. We'll start with the first question from Commissioner Sedwani.
Thank you. Welcome back. Welcome, Mr. Stromwasser. We're very happy to have you here. Yes, indeed, this is just a formality question. Please confirm California Bar memberships for every member of the team and address any issues that might arise.
I know this is your favorite question. The answer is everybody is a member of the California State Bar, including Mr. Becker, who is actually still considered a member of the bar, but is on inactive status until the need would arise for him to go to active status, and he's prepared to do that at a moment's notice. He's got the checkbook ready and is just waiting for a reason to have to do it.
Very good. Second question, Commissioner Toledo.
Thank you, Commissioner. And I think this question was answered yesterday, but the public must have a high level of trust and confidence in Council's ability to provide objective, balanced, nonpartisan advice to the Commission. How can you provide that assurance?
So that we're not completely repeating, I'm going to throw this one to Michael, and he can give you his perspective on this response today.
Yeah, even the new kid on the block is probably going to sound familiar. First of all, as Fred said, we represent public agencies. That's what we do. We represent public agencies and officials. We know the lines between policy and law, and we understand which side of that line we would be on. We understand the sensitivity of particularly your work because it is going to be so in the news, and we understand how to avoid making bad news for you, and how to help make sure that the stories are as favorable as they undoubtedly will be justified in being. The question has also to do with trust and confidence, and I would like to make a pitch on that. Much of the job of an administrative law specialist representing an agency is to win the battle over the standard of review and deference. How hard is the court going to look behind what you're doing, and to what extent are they going to feel like they can trust you? And it turns out that has really important implications for how they look at the case and how the case turns out. And so we think it's really important to, first of all, build a solid record, a record that reflects that you did in fact reach out to people and solicit a diverse group of people for input. You have you've done the research, and you have provided a reasoned explanation of what you did. And the stuff that the court is going to want to see, and the only stuff that you'll be able to cite when you get to court, is going to be the stuff in the record, and you have to make sure that that's the stuff that's actually there. There's an old saying that every lawyer has 3 trials: the trial he plans to put on, the trial that is actually presented, and the trial that you wish you had presented. And you frequently find yourself as the litigation counsel looking back and saying, geez, I don't know what those guys were thinking if they'd only put this one piece of paper into the ring. And so our job is going to be to help avoid that consequence. In terms of nonpartisan advice, I would just like to offer one anecdote, which is when we opened our doors 30 years ago, as Fred said, the insurance commissioner was our first client. I was in court yesterday representing the insurance commissioner. And over those 30 years, there have been 5 elected insurance commissioners, 3 Democrats and 2 Republicans. All 5 of those have looked to us for advice and representation, and keep coming back because they trust us irrespective of partisanship.
And I'll just add briefly, really this question is so key. It goes to the core of my entire career and the way I've worked, the issue of having credibility to work in a nonpartisan way, which leads to credibility with the courts and others. It's one of the reasons I was so excited to work on this project and with this team. And going back throughout my career, particularly in the voting rights context, I have litigated cases against Republicans. I've litigated cases against Democrats. I have had co-counsel that were Democrats. I've had co-counsel that were Republicans. And when it comes right down to it, sticking with the law, the data, the facts that are there, really inspires credibility with the courts. I've just realized I never really thought of what my record was in the courts on these voting rights cases. I'm pretty sure I won almost all of them, but I might have lost one here or there. But most of the time, that credibility is absolutely essential with the courts. The courts don't hear these voting rights cases all the time. They're not cases that come to the courts every day. So they're really looking to counsel to help guide them through the sometimes very intricate data that's there, and to have the credibility to do that where it looks like you're not putting your thumb on the scale for one party or the other, which is of course what's happening with at least one of the parties to the litigation, and to be there as telling them the straight facts and having a justifiable plan that you can defend. That's really what it comes down to. It goes to the core of my work throughout my career.
Thank you. We'll go to question number 3. Given your experience with redistricting, what are common mistakes made by other boards and commissions which result in litigation being brought? And how can we avoid these pitfalls? What action should the commission take now to mitigate litigation risk in the future?
Yeah, this is a great question. So first I'd say you want to have flexibility when you're drawing the plans. You're balancing a lot of different factors, and those factors are all important. You can't dispose of any of the important factors, even while some factors might have priority. So making sure that you don't tie your hands too much while you're drawing the plans or during the entire process, so you have flexibility where you might need to move a little bit of population here or there to have some slight deviation, particularly the state legislative plans, of course, where that's allowed, is really important to maintain balance with the other factors, such as the Voting Rights Act and offering minorities the meaningful opportunity to elect candidates of their choice for they're large enough and cohesive enough, which gets to the second point, which really gets at the Voting Rights Act. I think that's really where you have to start first and foremost. And having quality data, and that's going to start, and we mentioned this yesterday, that's going to start really as soon as you can, even though we might not be able to have access to the census data until later this late summer or fall. There's other data that's available that might help point us in the right direction, that might help avoid pitfalls in the future. So really having access to quality data and applying it to the Voting Rights Act as best we can. And I mentioned yesterday, it's a very fact-intensive inquiry, having the right kind of experts on the right kind of racially polarized voting analysis to let us know where the opportunity to elect candidates of choice for minority communities really exists. And then lastly, and this might be most important, really engage with the public and the communities out there and the communities of interest out there, the minority communities in particular, but everybody, and get their feedback. And this is not just a one-way feedback, this is a feedback loop. It's really important to hear from communities where they believe there might be an opportunity to elect candidates of choice, where their political power might be something that might be diluted otherwise if they don't mention it. And so that we can hear that, so that we can focus on that during the drawing process, and then make sure that the plan is as defensible as possible, particularly where we might have data issues. We're of course concerned justifiably about potential undercount issues with this past census, and the lateness of the census data is going to add to that. So community input is going to be incredibly important. And that, I mentioned the feedback loop, it also affords us an opportunity to inform the public about some of the requirements, some of the balancing of interests that are naturally going on, so that we can have a feedback loop between us and better inform the process that will ultimately really benefit us in the litigation. Because the litigation, I think we're going to talk about this a little more. I think you know this. It's highly likely there will be litigation over this or all of the plans. That's true in almost every case. There are political interests in play, and political power often yields litigation in this context. But the Commission's concerns, I know, are not political. They're about fairness, they're about representation, and to be able to provide, to be able to tell the story fairness, both in the drawing process and then in the litigation process, is ultimately key.
It's catchy. We'll go on to question 4 with Commissioner Sedwani.
Thank you. This is really, to some extent, an extension of the prior question. If the Commission successfully files its maps on time and in good faith compliance with its constitutional requirements, on what basis are its maps most likely to be legally challenged?
I think you're right. It is an extension. And the short answer is they're going to get challenged on any ground that anybody can conceive of. And they could get challenged on the color of the paper that you print your report. The people who challenge the plans, you will find, are not necessarily doing it because of the legal argument that they will make against it, but because of the result that they object to. And the difficulty, particularly in a year when California is likely to lose at least one congressional seat, so we're going to have fewer seats. It's just inconceivable that there won't be an objection and a legal challenge raised. Which, now obviously the most legitimate and most likely challenges substantively would be to this kind of narrow line that the Commission has to thread between compliance with the Voting Rights Act and compliance with the Equal Protection Clause and the Shaw type claims about how much can you consider and how much do you rely upon race in determining the boundaries. And that's, we've talked about that. We've talked about the analogy with the driving the car and checking the speedometer and keeping to the speed limit. And that is going to be a very difficult line. And inevitably, it creates an issue for one side or the other to be able to challenge it. Perversely, you might even find the same party challenge it on both grounds, even though they seem to be in conflict with each other. So I think substantively, that is like the most likely kind of challenge. It occurred to me, however, that there's going to be, you may find yourself in 2 rounds of litigation here. And we talked about this yesterday with respect to the timing, and then I really didn't think about it until more recently in terms of how that's going to affect litigation as well. How delayed this process is. We talked about how difficult it's going to be for the registrars to start taking what you come up with, the maps, and putting them into play for an election that is going to be starting, weeks later. That's going to have an impact, I think, on litigation as well. And so what we'll probably see is an initial round of litigation trying to stop these maps from going into effect, because a true legal challenge to the maps, with the briefing and with the expert testimony and all that would entail, that's going to extend well beyond the deadline for this first election under the new maps to be conducted. So you'll probably get a mini round of litigation that will be precisely over whether the commission's maps should be used for this first round, similar to what we had 10 years ago when there was a referendum effort. And the question was, okay, if this referendum qualifies and automatically stays the commission maps, what are we going to use for the first set? And what that means is that first decision is likely going to be made both with looking at the merits, but this other point that we've pointed out to you, it will also depend largely on the regularity of and the confidence that the court has in the procedures that the commission has used to get those maps in the first instance, because the court won't be able to really give it that full look on the merits of it. And they'll have to say, okay, do we trust the process? Do we trust all the outreach? Do we trust all the input that they got? And do we trust that they made a decision that we're going to give them presumptive validity to, at least for this first round of elections, while we have to litigate the merits later? So I think that's another thing to be prepared for, is that there'll probably be a very quick round of litigation that relates to a kind of broad brush look at what was read, and then probably a continuing and second round of litigation over the actual merits of the plan. And then there may be issues relating to some of these relating to the composition of the commission. I think there may be a laches problem with nobody's brought that yet, but who knows? And of course, there will be, unfortunately, probably challenges to some of the interim decisions that you've make along the way in terms of the data choices and things like that.
Yeah, I'd just add, having litigated a lot of these cases, there is no such thing as a perfect plan, and there's no plan that will satisfy everybody, because political power is at issue. And so when you ask what the basis that the plans will be challenged on, the real answer is politics. The legal answer is whatever claims they think might stick. Now, when I was with the Justice Department, one of the things that was really important was we always set ourselves up, and this relates to the prior question, as kind of the authority on these issues, as someone who was not trying to put the thumb on the scale one way or the other. And I had cases, including the Georgia case, where we were the plaintiff, the Georgia Democrats were the defendant, but the Georgia Republicans came in as interveners on our side. They argued that all three plans were illegal. The Democrats argued that no plans were illegal. And the Justice Department came in and said, we have problems with 5 districts in this one plan. That's it. And so we had an inherent credibility there, but that gives you an idea. The legal basis might include the minorities in this district are not sufficient to give those minorities an opportunity to elect candidates of their choice. So the numbers need to be higher. In other words, you might need to pack more minorities into that district. And the political goal might be to make other districts a little more flexible politically towards the plaintiff. Or the opposite of that is race predominated too much in this, and you put too many minorities into a district to create a district that didn't need to be drawn in some way. And again, politics is the ultimate goal of that. But I think this all goes back, as Fred pointed out, to the process. If the process is transparent, if it involves enough engagement with the community and at early access to data that the community can also look at with regard early, so they have a chance to review it and see what the data shows, I think is really important. courts do not expect you to draw a perfect map. They expect you to draw a map that complies with the law and is as fair as possible given the circumstances. And that's a reasonable goal. And I even with the challenges that California has because of its diversity, I think it's a goal that can be met in California and be entirely defensible in court.
Thank you. We'll move on to question 5, and we do have about 20 more minutes, and so I think we need to probably pick up the pace just a bit, if possible. Question 5 with Commissioner Toledo.
Thank you, Commissioner Yee. How would you view your role when working with the VRA counsel retained by the Commission in avoiding potential litigation as well as defending the Commission during litigation? And how do you envision your role in working with the CRC line drawer and with other staff?
Well, I think that does lead on from what we've been talking about here, a need for coordination from the earliest possible time. That you want to have that kind of coordination, that kind of collaboration without duplication and without additional costs or repainting the exact same picture. So I think we have the capacity to do that. Again, this firm has been doing that for 30 years. I like to think I was doing it in my offices as well, that you reach out, if it's the general counsel or if it's the staff, to have the kind of full and complete communication, a sense of shared mission, and that would include everyone from the line drawer to the most junior of the law clerks. It's the way this firm has been practicing, and it's the way results are achieved. And even if there are appeals, and of course, in this case, we know there will be appeals and there will be challenges. It did remind me about early getting that information out to the public in the last question, because one of the major criticisms in the Los Angeles County plan in 2010-12 was exactly that there wasn't enough on that website. There wasn't the early data. Those were the most crucial complaints, and the ones, had they litigated, I think might have made a difference.
Okay, we can go to question 6. The census data will present the Commission with several new variables, including timeline delays, questions of data quality, the new differential privacy policy, and the new inmate reallocation policy. What new litigation risks, if any, do you see for the Commission in these developments?
All right, well, trying to be brief. I think that most of these problems are upstream, Commission, frankly. And so I don't know that they're going to present a lot of litigation risks that you could avoid, because some of these decisions are being made in the people who are giving you the data that you're required to use. There's obviously going to be some flexibility that the Commission has in how it uses these data that it gets. And therefore, we should be mindful of that flexibility and using that flexibility appropriately to counter any aspects of this data that we think is problematic. For example, however, you look at the reallocation policy, for example. I understand that you folks have already made the decision to accept that policy in the use of the database. Somebody, yeah. So I mean, and that came to you, and that's frankly a decision that I think is very safe. There has been some litigation over that in other states, in New York, I think in particular, and that policy was upheld. It's clearly the policy that the legislature seemed to want. So I think that's a very safe decision that you've already made. But yeah, somebody may sue over that if it determines that the ultimate outcome they don't like. Similarly, the census, the differential privacy stuff, I mean, that's a decision the census is making. They're giving you the data. You'll be able to analyze it in different ways. And like some of the issues with the undercount and other data quality issues, there are ways to compensate for it. You've got to make the record. You've got to get the feedback on it and proceed. But I think those really should not be primary concerns.
Okay, we can go to question 7 with Commissioner Sedwani.
Thank you. After the Arizona 2015 case, we've generally considered independent redistricting commissions to be unconstitutionally safe ground. If HR 1 should become law, how might it affect the commission?
Okay, yeah, I'll start with this one too. First of all, I don't want to be a prognosticator but I don't really think we have to worry about HR 1 becoming law and affecting this redistricting cycle, but leave that aside. We should be monitoring and we should be aware of it. HR 1 is not, well, let me as a strict matter in terms of what HR 1 would require in its current form, the commission's great. HR 1 would require those states that don't have redistricting commissions to have redistricting commissions. And it has a grandfathering clause for those states that do have it that California meets, as far as I can tell. So it would have no negative impact on you in terms of what it provides. Ironically, and this relates to the Arizona versus Arizona case, the one negative that HR might create is that if it were to pass, it would likely get challenged on constitutional grounds that could then force a court with a different composition to re-examine the Arizona decision. Again, I think that's a longer term problem. I don't think that can happen for your work and affect your work and this redistricting cycle. But it is a kind of ironic potential result from HR 1. I will say this whole notion of citizen initiatives for redistricting commission is an issue that we've been deeply involved in. Initiative and referendum has been kind of my passion for the last 20 years, 30 years, the most recent case in the Supreme Court related to that. So if it did get involved somehow, we'd have to defend it. We'd be really happy to take the lead on defending this model of democracy, direct democracy.
Yeah, and I'll just add very briefly, Fred's right, Section 2401C of HR 1 very clearly exempts states like California that have existing commissions that meet certain criteria, which California does meet, which is not surprising because California in many ways was the model for this section in HR 1, meaning California is ahead of the game, which is fantastic. I think it is factually probably true that HR 1 has an incredibly steep uphill climb to get to passage. But even if HR 1 were to pass, and if it were challenged in court and it went to the Supreme Court, I think exactly right. It's unlikely that they would review the Arizona decision. But if they don't review the Arizona decision, it would not affect the state's decision to move to an independent redistricting commission. California is on very, very solid ground with regard to its independent redistricting commission law.
Thank you. The longest question will come from Commissioner Toledo.
Thank you, Commissioner Yee. The commission will have to defend being racially conscious in its decision-making as one of our criteria in creating districts. California is also uniquely diverse state in terms of racial and ethnic minorities. Over the last 10 years, numerous lawsuits have occurred throughout the state under the California Voting Rights Act. How would you defend the constitutionality of majority, minority, influence, or coalition districts that the commission may have to draw? How would you advise the commission to use or not use partisan election data in pursuing VRA compliance and defending its work?
Well, for the longest question, hopefully David can give the shorter answer. We addressed it a lot yesterday too.
Unfortunately, we covered this a bit yesterday, exactly. So first of all, the commission is required to be racially conscious. Federal law requires that, but requires also that race not completely predominate over all other factors. I think there's a couple of things that I'd say about this. First, it's really important to be transparent and have good data that can be analyzed and be made public as quickly as possible. This is particularly true where you've got, as California does in a way unlike any other state, a great diversity of minority communities, most of which are very, very complex in how they vote. So having good assessment of racially polarized voting patterns early on and really trying to get a sense of what that means. And then the second main part is getting input from the community on that to help educate and inform about what the data shows. So that feedback loop is going to be very, very important. This is the process which is really going to define how well these cases can be defended in court. Again, processes that are transparent, that involve community input, that involve a diverse set of data are highly defensible in court. I think you've already established a framework for that, which is really, really good. Putting that framework into effect in the coming months as we start to input data into the system and analyze it and assess racially polarized voting patterns and get input from the community, I think will be essential. As for partisan data, there's no way to avoid data that has some partisanship, some partisan aspect to it. While it may be that certain minority groups tend to vote for people in particular political parties, it may be that people in particular political parties don't vote for some people in minority groups, and that not all the people within a political party are the candidates of choice of particular minority groups. This really gets to the granularity of the data. We really need to look at the racially polarized voting patterns, including primary data. Even with the top two primary, it's very likely that we will see clear patterns in some minority communities about how they cohesively vote and who their candidates of choice are. And so in those cases, we should take that into account and use it, even if it has a partisan effect. I mean, minorities are allowed to vote for partisans just like everyone else is allowed to vote for partisans. And there may be a partisan effect so long as the overall plan isn't designed to create a partisan effect, which clearly under the framework you've established and that's been established under law, it won't be.
Thank you. We have the last question. Please explain the budget you propose and your ability to work within the billing schedule as provided in template form by the Commission. How would you allocate your time among the necessary tasks, including attendance at Commission business meetings and input meetings? Where can our staff and your firm work together to constrain costs? Describe generally the work product you will provide and how you arrive at its proposed costs.
Well, as you maybe remember from last time, this is not my favorite part of practicing law. Although I have been on both sides, I have been the client, and the client that has the responsibility not only to set and accept the budget, but then to enforce the budget. And I have been the hired lawyer on the other side, defending the budget and explaining why it had to either increase or decrease. How we would do this is first we would follow your guidelines, and this firm has had a history over all of this period of time of following very different governmental guidelines successfully. And the next most important part is to be as transparent with the client as we will be in any other context, and to understand exactly what we're working on, who's working on it, trying to do it in the most efficient way possible, and of course, relying upon the staff and relying upon all the other partners in this, because that way, by coordinating without duplicating, we get a much more efficient project. And I'll turn it over to Michael, who's been doing it here, as everybody has said, for 30 years. Michael.
When you're old enough to have been doing this for 30 years, you're also old enough.
Absolutely.
First of all, we work with in-house counsel, staff attorneys, and technical staff of all of these agencies. We consider that to be essential and an opportunity that helps us deliver a better product at a lower cost. I want to address briefly the one piece of cost that you have on the litigation side, you have some control over, because obviously the cost will be dominated by how many times you are sued and how extensive the litigation is. But I would like to assure you that the rates that we have proposed to perform this work, that those rates are very reasonable. And we have something of a yardstick to offer you, and that is that we, a fair part of our practice involves public interest litigation in which we represent a group or an individual on a contingent basis. In those cases, when we win, we apply to the court to actually set our fee amount. And the court has a formula that's been laid out in a bunch of cases. And the first piece of that is, what is a reasonable hourly rate for the work that, for the services of this lawyer? And we are receiving from the courts hourly fees that are roughly double the rates at which we are proposing to represent you in this matter. So you can be assured that these are reasonable rates that are understating our market value in the legal market. But we are happy to suffer that economic loss for the opportunity to represent you and to be on the right side of the issues.
Okay, well, we actually do have 3 more minutes. If you have any questions for us or any further comments or any further questions from the commissioners.
I just have one comment that I think is a little bit under the surface here, and I just wanted to expose it because you probably will discuss it and just get our view on it before. We are the only firm that has applied to be both counsel in both positions, and we do think that there's a natural fit there. I just wanted to, to give you our perspective on that. And I think you have heard the coordination between the litigation counsel and the people who are preparing the record and working with the commission throughout to get to that point is very critical. It does not have to be the same firm by any means, but we think that there are advantages to it being the same firm in terms of a consistency of position, in terms of efficiency, cost efficiency, and otherwise. We don't have to send double representatives to monitor meetings and things like that. And we say this, and we do not expect that we would also be the experts who would be then defending the plan if it, when it got to court. That is not necessarily the role of the VRA counsel, or certainly not the role of litigation counsel. There would be, we anticipate, somebody else that would then be reviewing the commission's work as an independent expert before the court. And we just wanted to clarify that a little bit, because I know it came up in some of the other discussions.
Yeah, and I just add very briefly, California has a wealth of experts and researchers that, especially at many of the universities, that are great. It would be great to have an opportunity to work with them in defending the resulting plans.
Indeed, we have one of them on this commission and in this committee. Okay, any other thoughts from anybody?
Thank you.
Thank you so much, and we wish you the best, and thank you for your interest in this position as well as the other one. We've certainly learned a lot, even in just these interviews, and we appreciate the chance to spend this time with you and to think about the possibility of collaborating. So thank you.
Thank you. Thank you very much.
Okay. It's 1:55. Shall we go ahead and take a, let's say, you want to take a full 15-minute break at this time, and come back at 2:10. And at that time, we'll take public comment and leave public comment open for the rest of the afternoon while we discuss these candidates.
Thank you.
Thank you, and welcome back from our break. We've completed now all 6 interviews. for VRA Counsel and Litigation Counsel. And this afternoon, we'll be discussing the Litigation Counsel interviews and possibly coming up with a recommendation or a ranking at least. It's possible we could also finalize our recommendation today, but if not, we'll continue this discussion in tomorrow's session, and where we'll have discussion only and no further interviews. Anything to say before we go to public comment? Commissioner Samwani?
Chair, not that we were thinking of going later, but I should just mention I have a hard stop at 5 o'clock.
Very good. And our next break, by the way, will definitely be no later than 3:40. Okay, Katie, can we go to public comment, general public comment on litigation counsel interviews?
Yes, Chair. In order to maximize transparency and public, well, hold on one second. Here we go. In order to maximize transparency and public participation in our process, the commissioners will be taking public comment by phone. To call in, dial the telephone number provided on the live stream feed. It is 877-853-5247. When prompted, enter the meeting ID number provided on the live stream feed. It is 935-6444-6340. When prompted to enter a participant ID, simply press the pound key. Once you have dialed in, you will be placed in a queue. To indicate you wish to comment, please press *9. This will raise your hand for the moderator. When it is your turn to speak, you will hear a message that says the host would like you to talk, and to press *6 to speak. If you would like to give your name, please state and spell it for the record. You are not required to provide your name to give public comment. Please make sure to mute your computer or live stream audio to prevent any feedback or distortion during your call. Once you are waiting in the queue, be alert for when it is your turn to speak, and again, please turn down the live stream volume. And again, when you call in, if you can press *9 to raise your hand, indicating you wish to comment. Thank you.
Thank you, Katie.
Yes.
And once again, we'll go ahead.
Oh, I was just going to say, someone did call in right now, but they have not raised their hand yet.
Okay. As with yesterday,
they raised their hand.
we'll be leaving the calls open for the remainder of the session today. So let's go ahead and go to our first caller.
Will do. The floor is yours.
Hi. Thank you so much. This is Renee Reed. I hadn't planned on calling in yesterday, just as I hadn't planned on calling in today. But since the same issue has come up again, Google Gibson Dunn Political Action Committee, or PAC. Click on the very first link, which is their Open Secrets report, and click on Candidate Recipients at the top of the page. Pick an election cycle in the drop box, and you'll see contributions to California congressional candidates every cycle, including contributions over $2,000 in 2016, 2014, and 2012. These were not disclosed in your report or their interview. They are contributions by the firm, not by individuals, less than Ake and Gump, but again, undisclosed. Sorry if you already knew this, but I know non-disclosure was a big deal for the commission 10 years ago. And your RFI asks applicants to, quote, identify any political contributions, including contributions made by a firm, political action committee to candidates as described in California Government Code Section 8252 during the past 10 years. So, since I raised it for one firm, only fair to raise it for another. Thanks again for your time and good luck.
Thank you, Ms. Reed. We appreciate your calls yesterday and today.
And that was it for now.
Okay, please keep the line open and we'll watch for you. Okay, open discussion. We have three, I would say three strong candidates. For me personally, it seems like a bit of a harder choice this time than yesterday. But, any general comments before we go to the worksheets and look at each candidate in detail? If not, we can go ahead and let's start in order with Gibson Dunn. Sending a large team to us, citing the 2010 Commission's experience with them quite a bit. I did note that they did not acknowledge the role of Morrison Forster, which was also counsel in 2010, and actually picked up the greater share of the litigation work at the end, I believe. But otherwise, certainly very extensive experience in these matters, a lot of background, a lot of depth, a lot of cases argued. For me, that was probably an exceeds, maybe an exceeds minus just to acknowledge Morrison Forster. Any thoughts?
On this point, I would agree that it is an exceeds, or even I would even say an exceeds plus. I certainly, if I take off my commissioner hat and I'm wearing my research hat, I actually disagree with their perspective on the Santa Monica case. However, that being said, their purpose as a law firm is to win. And I think they, in terms of their relevant experience, they have a strong track record of doing just that. My sense is ultimately we, as the commission, need to hire attorneys and a law firm to protect us from potential litigation and to uphold our work on behalf of the people of California, and we're not necessarily hiring them based on their, shall we say, moral standing in the CVRA. And so on that, in terms of their experience, I think that they certainly exceed.
Commissioner Salmani, maybe you could very briefly just describe the Santa Monica case just a bit for anyone who's listening who may not be familiar.
Sure. And again, I'm not an attorney, so I'm probably not the best one to look at that case. The CVRA, of course, deals with a remedy for at-large jurisdictions in or elections in municipal districts, municipal jurisdictions such as city councils, school boards, etc. The concern there, of course, is the extent to which minority communities can elect the candidates of their choice. The city of Santa Monica was holding at-large elections. They're in the trial court under the CVRA had agreed that they should switch to district elections so that particularly Latinos could have a more fair opportunity to elect candidates of their choice. In the appellate court, they overturned that. They overruled it in part because of the size of the Latino community in Santa Monica and what that would ultimately create in terms of the kinds of districts that could be drawn. And I think particularly at interest is the fact that even in switching to district elections, it does not create a majority-minority district, which was my interest in including the question around influence districts, coalition districts, and majority-minority districts. California is a very diverse place, and so it's not always the case that majority-minority districts can be drawn. However, I suppose an open question, as we heard from many of the the attorneys today as well as yesterday in terms of VRA on this matter is, are there other remedies that can be taken that are legal, right? That are legally permissible or mandated even, to protect communities at lower levels in which they would not create a majority minority district. My own research doesn't exactly pertain to the VRA necessarily. It looks at simply what happens when you have various proportions of minority communities in a district. And, I find in my examination of turnout that it is the proportion of a minority community in a district that leads to greater levels of participation and increased voter turnout. Other work would point to substantive representation. So that's why I say I disagree with their perspective. However, of course, they were very persuasive in winning at the appellate court level. We'll see what the California Supreme Court has to say on this matter. But certainly, I think, given that, I can see how we would want them on our side and representing us as opposed to potentially, right, representing an adversary.
Right. Thank you. Okay. Any other thoughts on relevant experience? We can throw in personnel as well. They're a big, successful firm, so very impressive personnel for sure. Lots of relevant experience. I have to give them an exceeds on that too. Any other thoughts on personnel? If not, we can take a look at their plan. Of course, plan is a little more wide open for litigation, since so much will depend on what challenges are actually brought. And, there's just no way of knowing how many or what, on what basis they'll be brought. So,
on that matter, and I agree with you, the plan is far more vague for the litigation counsel. I did appreciate, and this kind of speaks also to their fee structure. I did appreciate that, their suggestion and openness to negotiate a flat fee for meetings and to send a junior associate to be in attendance wherever we choose for them to be. And I think we heard across the board from all of the the interviewees today, the applicants, that having the litigation team be a part of the process as much as possible, right? To constantly be present and kind of thinking about potential litigation, recognizing and knowing that I think it was Mr. Wucher who had said litigation can be brought if we put it on the raw, for the color of paper that we use for our report. I think, of course, I think there's some truth to that idea that there's any number of reasons why people might want to bring litigation against us, and therefore having any of whoever we select have a presence in our process from here on out. Makes a lot of sense to me.
I think in terms of plan, they do have the experience of having worked as the commission's legal representative last time around, and that experience does potentially give them insight that maybe other firms might not have in developing a plan. And they did bring that up. I believe once or twice that they had some of these. I believe two of the members of the team have previously been involved in commission work.
Although, to be fair, we have had mixed reviews, from some of the folks who were there around then, as well as the fact is Morrison Forster did need to be brought in later in the process. There's a long story behind that. Of course, they put the best face on it this morning, but as far as I can tell, it was a quite complicated story as it unfolded 10 years ago.
Could you share your impression of that ordeal?
I'm sorry, I didn't quite catch all of that.
Oh, could you share your impression of that ordeal or that story? The relationship between the two councils?
Well, let's think. I was referring simply to the fact that, it could have been the case that Gibson Dunn was fully satisfactory in all ways and was the sole counsel throughout, both the VRA process, map drawing process, and the litigation process. But in fact, there were various points of disagreement and tension in the work relationship, such that Morrison Forster eventually came in, and they were both retained through the end. But I believe Morrison Forster, at least when I look at the billing records, did the greater amount of the work at the end. So that speaks to something, that a different firm had to be brought in, and later in the process. Yeah.
Thank you. Yeah, I knew that there was a secondary law firm. I wasn't familiar with the particulars of why they were brought in or what the thinking was in terms of that decision. Certainly, you and I have noted through some of the VRA subcommittee work and the development of the RFI, there had been documentation about Gibson Dunn's performance in terms of VRA counsel. And notably, they didn't apply for VRA counsel this time.
I also think that that's something that can come in the reference checks as well, in terms of that information and that calibration of the score can potentially come in and through reference checks and other processes, right?
Sure. Okay. Anything else on plan?
Where did we leave off in terms of score on the plan for Gibson Dunn?
I don't think we landed. I find myself I feel like giving them all a meet, because it's just hard to exceed on something when we don't really know what's coming down the pipe. I mean, they all basically said the same thing, So I don't think that's going to distinguish them.
That's fair.
Conflicts of interest, which is something our most recent caller raises once again. The city of Santa Monica case in and of itself, I don't know how to weigh whether that's an issue.
I mean, I don't see it as a conflict. It's not a federal law. It's dealing with issues that are different than ours, not within our statute. I don't see it as it might be seen as a potential conflict, just given that, I think it goes more to values than to conflict. For me, it's whether these applicants hold, or this particular law firm shares the values of the commission in terms of ensuring fair access, ensuring that everyone has a fair opportunity to elect people of their choosing, and as opposed to a conflict of interest. Certainly, I think callers and others have brought in made important points about disclosure, and the question becomes: did they disclose all of the potential donations and other kinds of work that might be considered conflict of interest, and that I'm not 100% sure of at this point. But certainly there have been public input about them not being so forthcoming, both in the interview process and in the through their disclosures in the application.
Right. And I think in our further research, we did establish that a firm's PAC that is relevant to their disclosure of donations and activity. So, any other thoughts on conflicts of interest? On one hand, I feel that the commission could have been more skilled and clear in exactly what to ask for. At the same time, it's not entirely obscure, and these continuing issues being raised by the public and in some of our own research are concerning. And they do not add to the trust that we want and need in this relationship.
For me, I think it goes back to disclosure, just like yesterday. We just want, it's about making sure that the public understands the potential conflicts of interest or the real conflict of interest that exists, as opposed to them being left in the dark, right? So it's really about transparency.
I tend to agree with that. I think from our conversation at the very beginning of our meeting this morning, and Ms. Yang had weighed in a little bit on this issue. I think one of the challenges is that point 4 conflict of interest of the RFI was somewhat vague, as is section 8252. I tend to agree with Commissioner Toledo on this, that the purpose here is transparency. It's about disclosure. The financial contributions don't necessarily disqualify any of our candidates, but simply what we're requesting is that disclosure. And I guess the question is, do we feel like that has been met or not? I think however we proceed, I would want to simply ensure that both Aiken Gump as well as Gibson Dunn are treated the same in whatever we decide.
Absolutely, yeah. So how do we come down on a rating then with some of these questions that are hard to resolve? I mean, partly it is transparency. I think for me, still though, it also, none of these are disqualifying as they would have been for us as commissioner applicants. At the same time, they're factors. The public looks at one firm, looks at another. This one is super active politically versus another. That is a factor in building or eroding public trust. So, a firm can say, well, if you look at it, we contribute to both sides, equally. True. That, even that level of political activity is a factor in how much the public does or doesn't trust you to be impartial.
Perhaps it makes sense just to take a few moments to review that conflict of interest
Sure.
Disclosures that they did give, which appears on page 13 of their application.
I'd be curious to ask where Commissioner Yee is landing in terms of scoring on this. Would be meets minus or lags? Is in the spectrum of our scoring?
Well, if it's true that there are items that we're finding rather easily, that the public is finding rather easily that were not disclosed, then that would definitely be a lag, right? That would be a lag at some level.
Thank you.
I mean, I think even if it is a bit vague, as long as it's not a stretch, as long as it could be fairly easily construed to include such items, I think they're relevant. So
I was just checking my notes from what we had scored Aiken Gump yesterday. And certainly the two firms are not the same, but I think they have very similar considerations. We had scored them as meets minus, according to my notes.
And that's what I was leaning towards as well. I was leaning towards the meets minus. Given that that it's not disqualifying, that it's in our discretion, that to some extent some of this information is public, but there was less than or at least at this time it seems like there was less than full disclosure on all of these issues, but potentially the RFI wasn't as clear as it could have been.
I think that's correct. And in looking at the responses of some of the other applicants, I mean, I think across the board, and I mentioned this earlier this morning, the RFI was not entirely clear. And I think what happened, particularly once we put that conflict of interest report together, in which we scoured the personal giving and lobbying activities of each of the members of the applicant teams, is that we uncovered everything. We didn't ask for everything. So across the board, I think what I saw in many of the responses was, for example, I think one had said, my apologies, I thought it was only for donations of $2,000 or more. And yet in our research that we did, we identified smaller dollar donations. And I think then people felt a need to describe them. So I think there is a little ambiguity to what we're asking for. However, that being said, I think as Commissioner Toledo is suggesting, this is all publicly available information as far as we can tell. We've done our very best to identify all of the concerns that we might have. And certainly the caller, Ms. Reed, I think has helped to further identify additional concerns and considerations.
Okay. Yeah, I'm comfortable with a meets minus, although I'm still leaning towards lag, especially if any of these concerns, just continue to stand and even grow. So, okay. How about fee structure? They talked about flat fee plus fixed fee plus hourly.
I mean, the fee structure seems reasonable based on the scope of work and the that is to be done, and the fact that they're willing to negotiate on aspects, I thought was it's a positive in this situation.
I think it's a positive, but then at the same time, I think I would have liked a little more developed plan and fee structure, at least as a starting point. If you say, okay, this is what we think we'll go with, we negotiate from there, is different than, well, we'll negotiate when we get there, which leaves us a little wondering and possibly, in the position where there'll be some sticker shock down the road, right? So.
I would tend to agree with you, Commissioner. The fee arrangement certainly does not put any dollar amounts on anything.
Yeah.
While they definitely said in the interview there was an openness to negotiate a fixed fee for meeting costs. I do recall conversations about the exorbitant costs that Gibson Dunn had from 2010, including charging the commission for photocopying and other such matters. So certainly that is something that we need to take into consideration were we to move forward with.
Mm-hmm. So, I'd say meets for now, just because, there was some sense of where this would go, but I would have wanted more.
I might be inclined to say meets plus only because they'd certainly acknowledge the willingness to negotiate those flat fees and even recognize, like, along the process that they would likely send a junior associate to report back, and it seemed like they had thought through to some extent how to be cost conscious at a very bare minimum.
Right. That was another pop-up thing.
Okay, so meets or meets plus. We'll pass references. How about the interview number 7 then? Interview itself. Overall energy, rapport, coherence, alignment with our values and mission. Very, very polished. No surprises there. Any one of them could have played a TV lawyer.
Yeah, I agree. I appreciated, what's his name, Matt Kahn's pitch at the end of I think he called himself a nerd, I believe, and said that he loves the redistricting process or something like that, yeah. Or independent commission. So I think all of that was fine. Mm-hmm.
I thought it was a good balance of general response and detail. Ms. Henry, when she was responding to the census questions, went to a lot of detail, but it was all relevant and well presented. Yeah, certainly. I mean, they were on topic throughout, and we're on top of. I felt very confident about their sense of what we're doing, why we're doing it. I mean, not that that's a surprise, but it communicated well. Yeah. So maybe an exceeds for that. It's a strong interview. Potential for effective evaluation, effective collaboration, and other factors. They didn't propose just a single lead for the project. 3 leads. That's a little worrisome. I don't know, for me at least. Be a little more clear if one of them. And Mr. Skolnick seemed to be the lead. He signed the application itself, but the application states that there would be 3 co-leads: Skolnick, Buttress, and Kahn. Maybe that's not a big deal, but
I think it would only be a big deal depending on how we define their involvement with us. And I don't think that we've answered that question entirely, right? Either as a recommendation to the commission or the commission as a whole. We have heard today from all of the applicants that when it comes to litigation, they feel like it would be very beneficial for the litigation team or a representative of the litigation team to be present, particularly when we are line drawing, et cetera, and to provide some general input on our processes. I think I heard that loud and clear from all of the applicants. The 3-member lead, therefore, I don't feel concerned by that, because when it comes to actually representing in court, having those three attorneys sounds fine. That sounds great.
Sure.
It's a very strong legal team. I
Sure.
don't know that all three of them would at any point in time ever be present in terms of the actual coordination with our process. That was kind of my impression of when they said it would be a junior associate. I'm anticipating Miss, what was it, Sauer? I might be saying her name incorrectly. Emily, I think it was, or
Sauer.
Yeah, or Mr. Adler, who would be present as the more junior associates, and quite frankly, that we would pay less to, I would assume, to have them present, but that they could report back to the full team.
In terms of their application, in terms of the interview, I think there's a strong potential for effective communication. I think some of that will depend on just our expectations of making sure that we have clear expectations of them and clear guidelines. I also just, as once we settle on a recommendation, I think there's also needs to be conversation about there may be, for whoever we pick, there may be a need to go back and negotiate some of these aspects, whether it's us having them assign a lead or having the fee structure be developed a little bit more aligned, because that is a negotiated, right? There's what the vendor wants, and then there's what we can actually afford, and there needs to be a meeting of the minds around that. So and potentially some negotiation. So I think that's part of the procurement process that needs to happen as we move forward.
Sure.
I do wonder if Alvaro has any thoughts on this matter, either in terms of collaboration, or as Commissioner Toledo, you're mentioning in terms of the procurement process and the negotiation of any kind of fee arrangement with a litigation team.
Yes, I definitely concerned about the fee structure. That is definitely on my mind. But as far as working with them, I think they do provide some good resources, and we could work with them definitely as far as the way they've kind of laid out their plan. I had noted that I really appreciate the fact that they were aware of the importance of the community of interest and public input. I mean, that was very clear in their discussion. So having them on board and understanding that piece of it, which we're working on, is really uplifting for me to realize that they understand that piece of it. So that was just my interpretation of what they were saying, that I appreciate. We'll work with staff and how we get to the point where we're collecting that data and how we're collecting that data.
Alvaro, any other comments from you on any of the candidates? Just since we have you right now, so we don't have to keep interrupting you. Any inputs?
I was just looking at the first candidate, so that I'll have to look back at my notes on the following candidates when we get there.
No problem. They did also, they mentioned collaborating as early as possible with the FRA Council, right off, which, may seem obvious, but I'm glad they mentioned that promptly. The whole attention to areas of possible challenge that we may be challenged on, that was good reality check. I mean, we should know that, and which is really internalizing that the quality of the maps may not be the issue at all. For somebody who just doesn't like the borders, they'll find whatever they can find. to challenge the process and possibly disqualify them. So I think all the candidates brought that up one way or another.
That's right. I actually thought that there was a lot for the full commission, including myself, to learn from these interviews. I think that there were so many pieces raised in terms of potential litigation. I really wish the whole commission had heard. My thought was simply just to at a minimum, kind of type up some of my notes from this conversation and hopefully share it with our colleagues, so that others can also be aware of some of these considerations. I think regardless of which team we go with, across the board, all of them raised excellent points that we need to be aware of and be thinking about as we move forward in terms of our process, accessibility, and other kinds of matters. I'm not sure if it's on the radar for everyone on the commission, but it should be.
Mm-hmm. And maybe just to mention for the public, just a reminder, we are the Citizens Redistricting Commission. So we're, lay people when it comes to redistricting. And the state has chosen to empower such a commission with this task. So, we do bear training, including in legal matters and how to shape our work in a way that keeps it defensible and strong all of that. So, okay, so potential for effective collaboration. I'm hearing a pretty positive evaluation, so maybe it exceeds for that. Anything else? For effective collaboration, I do like the fact that it's a fairly large team, which is true for all of them. I mean, that can also be a downside, I suppose, but it does bring more variety of personalities and so on. So potentially more avenues of effective collaboration. Anything else? How do we feel about the fact that it would be the same firm as 2010? Obviously, they would bring greater, bring that experience that only they have, as they pointed out, which is absolutely true, along with Morrison Forster, but among the ones that have applied to the position. On the other hand, there's the consideration that has come up in other ways for the commission of whether repeat appearances at any level of this work can work to entrench certain interests or certain level of expertise in small areas of the state and not keep it open to greater participation and greater access. Interests can become entrenched when they're repeated, so that's a consideration as well.
I'm not too concerned that it would be a repeat entity as long as they're able to do the job. And they do seem to have a very strong proposal, strong interview, strong information. Certainly there's some weaknesses there as well. And I think if there were issues in the past, I think I'd be something that we could delve into through the reference process or through the public comment process if individuals of the public are aware of any such issue.
I tend to agree with that. I certainly can see your point, Commissioner Yee, about interests becoming entrenched. And I think given all of the feedback that we've heard about Gibson Dunn's work on VRA Council in 2010, I would share that concern had they applied for VRA. They didn't. They're applying for litigation, which is potentially much broader, touches on a much broader range of issues. Could potentially touch on both state court as well as federal court, depending on the type of consideration that might be brought. So I don't feel like it's a complete repeat of 2010 because I think that there their role would be more isolated to the litigation, the broad array of litigation, as opposed to the specifics of VRA compliance. Ultimately, whatever we decide for our VRA compliance, they're going to have to litigate and uphold, and defend.
That's right.
So, we haven't, for example, seen the backlash from the community that we saw from 2010. I mean, certainly the applicants have been posted now on our website. The full applications have been posted on our website now over a month, I believe, or very nearly a month. So there's been ample time for the community to weigh in on any of these applicants. And we haven't, outside of disclosures, which certainly has been raised and we've discussed at length, I haven't heard any other additional concerns from the community, which makes me feel a little bit better about that choice.
Yeah, I'm a little disappointed. I was led to believe this would really be quite an event,
You were looking for more drama.
Well, I'm not necessarily desiring it, but anticipating it.
And ultimately, I think part of that may be that the last commission was the first commission, and there was, I'm sure there was potentially some distrust in what could potentially happen if the commission had advice that was partisan, and certainly, of course, that's something that we all are conscious about. That we all are, watching. But ultimately, as was mentioned a couple of times throughout the various interview process, legal counsel will give us advice, and we ultimately will determine the direction we go in. And so we're the ones making the decision. The commission and the independent commission, the commissioners make or the commission make the final determination.
That's right. I'm pulling out the actual budget for the 2010 commission, and for the public, this is available in the 2012, June 2012 meeting notes. So this was the final budget for the 2010 commission. For council, for the mapping phase, Gibson Dunn was billed 300. This is unbilled 308,000. Then 60,000 went to the RPV analyst, and then Morrison Forster 25,000. So the lion's share went to Gibson Dunn for the mapping phase. For primary litigation, Gibson Dunn billed 1.1 million. And Morrison Forster about 706,000. So I stand corrected on that. Actually, Gibson Dunn was still taking the lead, at least in billable hours or billable activity for the primary litigation phase. That's 1.1 million versus Morrison Forster 706,000 or so. And then for the later phase, last phase after the primary litigation, Gibson Dunn about 28,000, and Morrison Forster 134,000. So that's when Morrison Forster did the greater amount of work after the primary litigation phase. So just to clarify that. Okay, any other thoughts on Gibson Dunn?
Commissioner, can you read out you said during the line drawing phase, 300,000 plus for Gibson Dunn, 60,000 for RPV. And what was the third number that you quoted?
25,000 for Morrison Forster.
During the line drawing stage?
Yeah. January through August, yeah.
Well, so that's interesting then, because they wouldn't, Gibson Dunn will not be our VRA counsel, right? So it would certainly be a different distribution. And of course, this was 10 years ago. So we can anticipate that costs will have gone up. But this is helpful. This is very helpful information to have just as we move forward and thinking about how to contain some of these costs as well. I'm sure that's something, Alvaro, you're happy to hear.
Yes. And I believe the litigation costs are itemized in the sense that there's a separate allocation for them. The VRA council cost, I don't believe is itemized yet, actually, in our budget. There's still part of that. It's some undefined part of that big pot that remains to be allocated.
I think that's correct. And as we further have this conversation, we don't have to define it now, but and develop our recommendation for the full commission, this is certainly something that we should be taking into consideration. Particularly, I know that Director Hernandez is working on budgeting for the rest of the year and going back to the legislature for any adjustments to the budget that might be necessary. This is certainly something that we should have on our radar.
Okay, shall we turn our attention to the next group? Renee, Public Law Group. Another strong team, I thought. Certainly Mr. Cohen, a law student, is a great catch for them. Wow. So maybe we can discuss relevant experience and personnel together. List a lot of very interesting cases in their application, although I did note that they're not, the ones cited are not election law cases specifically.
Yes, I noticed that also. Definitely a lot of great representation of public entities. Somewhat less so, particularly in comparison to our other candidates, in terms of election law. Of course, Mr. Cohen, of course, is very familiar and notably a student of the UCLA Voting Rights Project.
Yes.
So probably a student of Chad Dunn's, I'm guessing.
Probably. Star student.
I would imagine, yeah. He was great, but certainly would also fall into this category of course, not currently being admitted to the bar.
Mm-hmm. Although he's taking the exam this summer, they said, so I don't know quite how to weigh that.
Not everyone passes the first time,
Not everyone
although
passes.
I'm sure he will be wonderful.
Yeah, for sure, the long experience and focused experience in public agency representations, just familiarity with work in the government and public sphere. That was all very strong.
Yes, that's correct. And perhaps I'm going out of my bounds here and saying as much, but as they were talking about their representation of public entities as well as commissions, we are, of course, currently without chief counsel. And I thought, oh my goodness, they would be an excellent firm to assist us perhaps in finding candidates for.
Yes, absolutely.
In terms of relevant experience, where do we feel like we would place them?
I think I would say exceeds minus. So, certainly fantastic experience representing public entities, but not a strength in, not a focus in election law. At the same time, who does? So,
yeah.
So
I may actually say meets plus. I don't know where we want to land on that. I don't know really what the distinction between
Yeah.
plus and the minus between these two really is, but and I think they had one or two cases before the U.S. Supreme Court. Is that correct? I think they had discussed. So certainly, if we were to wind up in federal court on some matters, they would have some experience there.
Yes.
But I think really their expertise is in the state court system.
Right.
I would tend to agree with Commissioner Sadwani in terms of meets plus. Just given the experience and direct experience with redistricting.
Sure. Okay, I'm comfortable with that. Personnel thoughts?
I mean, their passion for this work came out, and I really enjoyed seeing that from the various members of the team, and Mr. Cohen and others, and so that was pretty apparent, which I thought thought that was commendable and certainly aligned with our values and our interest and our passion of making sure everybody has fair representation.
Yeah, I agree. Thought maybe a little too much time spent about Ms. Rennie herself, since she's not on the team. I mean, of course, it speaks to the firm, and it was relevant and interesting in that regard. But I had to double check. No, she's not on the team, right? No, she's not.
I did the same. I did the same.
They did speak to Bagley-Keene expertise.
Yes, I think that's where I was kind of thinking about our chief counsel needs is around Bagley-Keene issues. Certainly that, they certainly seem to have that expertise in Bagley-Keene and the Brown Act, which in general I thought helpful, not necessarily from a litigation standpoint, but certainly something that we are in need of. But again, that's extraneous to our litigation needs.
So overall, I certainly felt it was a solid team. I think if Mr. McGinley's Stemple had been there, that might have, definitely been a plus. At the same time, did they stand out for me? I don't know. I didn't. I was satisfied, but not surprised. I suppose exceed should indicate some level of surprise. Wow, that's even more than I expected, right? Which I didn't really get, but definitely very solid.
So for personnel, are you thinking meets?
I think so. Yeah.
I would tend to agree with that.
I would also.
Okay, plan. We kind of already said everybody basically meets. I don't know if we can really say too much more. They all seem to be fully aware of the nature of the litigation position and things we can expect and things we can't predict. Conflicts of interest. They did continue to send in disclosure reports up to today or yesterday. Mr. Holtzman is a very generous man for this report. Commend he's committed to being involved in the public arena. There was various lobbying disclosures concerning the various cities, not related to redistricting, but that was all fully disclosed. So any concerns about their disclosures?
I would think it meets, right, her requirement.
Yeah.
I didn't see any issue with their disclosures, not that from what we've seen and what they've disclosed.
Right.
Yeah, I'm not sure how one would exceed in disclosure. So similar to the plan, I think we're typically questioning whether or not they meet.
Right, and I mean, looking at it's the greatest number by far of disclosed items are Mr. Holtzman's donations, which definitely have a partisan lean. Very definitely, which is not at all disqualifying, but it is a factor in public perception, right? So it's not that we wouldn't even defend it for him, but it is one factor in how we're perceived and how our work is perceived. So. Okay, how about look at the fee structure? I appreciated the comment about just their long history of working in the public realm and the sensitivity to costs that typically raises just the hourly fee of lawyers. People notice that readily, and
I mean, right. Presumably, certainly Gibson Dunn didn't disclose an hourly rate, but this is, of course, I think the most cost-conscious approach that we've seen, which I can appreciate.
So maybe we could say exceeds for this one. And this is the large, as I think Commissioner Sadwani noted, this is probably going to be the largest single budget item in the entire commission budget. So litigation.
Yeah, I do appreciate that they have a public sector hourly fee structure. They are public. That tends to be their area of focus, so that makes sense. And it is their hourly structure. I would think. I know that Gibson Dunn didn't make it, didn't put it in their packet, but it is available upon request, and it's their and it's certainly not a public sector hourly rate that they're offering. They're offering their standard hourly rates, but the structures tend to be pretty public, especially with the standard hourly rate, right?
Sure.
Did we just, Commissioner Yee, I'm just trying to remember right now, did we ask for them to provide us with their hourly structure or with their fee structure? Or is that just something we're working through the negotiated process and through the negotiation process in our procurement process?
Yeah, let me try to get my hands on the RFI.
Yeah, I don't believe we did. I have the RFI in front of me, see if I can find it. I believe it was fairly vague about how would you structure your fees. Not necessarily dollar amount or anything else, but fee arrangements. Here we go, section 6.
And if we ask, how would you structure your fees in the RFI, the response is we would structure it with our standard hourly rate. That is responsive, right? It may be not the response we would have wanted, but it's the response in the RFI. So in that sense, I think certainly this group has at least met the requirement, if not more. But I would think that Gibson Dunn did as well, in terms of being responsive to the question in the RFI, which was to explain how their fee structure would work.
Right, I agree, but at the same time, there's different levels of responsiveness, right? I mean, if you go out of your way to be even more detailed and be even more reassuring.
Absolutely, I agree.
So that wasn't exceeds for me for the fee structure.
Okay.
Okay, how about the interview itself?
And I thought the good rapport. I really enjoyed hearing from Mr. Cohen and Ms. Maldonado and their passion and others, member of their teams, members. Good rapport, strong communication. And passion throughout the whole process in terms of, I could see the why they applied and how it aligned with their work and their connection to the public sector piece.
I thought the intros went a little long, and I didn't actually put parameters around that, but it seemed like we were getting a lot, maybe more detail than we needed at the beginning there. It was all relevant, but at some point it was like, we're still in the intros. I started to worry that I was being unfair to the other teams that I didn't invite such an extensive intro. And then I noted that Ms. Maldonado clued us into her ancestry, which is all good. But she must have been listening yesterday. I might have been responding to a comment about diversity.
Oh, I think perhaps I missed that. I didn't notice that I know Ms. Orden did in the.
Yeah, I missed that as well.
Am I getting mixed up here?
Certainly, Ms. Orden did in the Stromwasser-Wucher, but I didn't recall Ms. Maldonado making reference to her background.
Oh, I'm sorry. I totally mixed that up. That's entirely correct. Yes, that's right. Yes. I take that back.
Okay. And just to note, I think that you were fair and equitable amongst all of the interviewees in terms of your opportunity to introduce themselves. I think that they simply, extended that at their own accord, and that's
sure.
I didn't see any problem with that.
This whole process has been so transparent in terms of the questions, in terms of being able to see other other applicants interviewing. So I don't think there's any fairness issue here. I think we've been very fair with all of the applicants.
I agree.
Well, that's one thing we've certainly had reinforced for us through this whole process is that the process matters. Yeah. If and when we get challenged, that's exactly what we need to pay attention to. Okay, any other thoughts on the interview?
Where are we settling for a score on interview?
I was thinking a meets plus. I could see an exceeds minus too.
Mm-hmm.
Yeah, I thought very solid.
Mm-hmm. Yeah, I agree. I think in general, very solid for the interview itself. The experience, however, I suppose it's a separate, the first consideration here. But I thought a solid interview. So I would support Commissioner Toledo's ranking here of meets plus or exceeds minus.
Okay. Yeah, I would say meets plus.
Shall we settle on that then? Okay.
So potential for effective collaboration and other factors.
Yeah, I think similar to as we've been saying, I think that they were three very passionate people, definitely a lot of great experience representing state bodies or local, municipal bodies. I don't question that side of it. I think the experience in election law, experience also beyond state courts would give me pause moving forward. And I think influences my perspective on the potential for effective collaboration. I don't see it as a personality issue by any means. I think they were all wonderful. And as I mentioned, like when I saw them, I kept thinking, oh gosh, we should really be talking with them about outreach for identifying candidates for chief counsel, especially given their extensive history working with boards and commissions here in California and knowing that side of the law. The litigation, however, I'm not entirely convinced that they would be the right firm for us.
I think they certainly could do the job, but are they the best of the three? I agree. It's not clear.
I would just, in terms of collaboration and just saying, I think you're right. I think Commissioner Sidwani, Commissioner Yee, in terms of those issues, certainly experience is an issue, and just being confident in their ability to represent the litigation side. Although they seem like very nice people, and I wouldn't mind working with them in other capacity.
That's right, exactly.
I think I actually would enjoy that. I think they seem like great individuals with great passion. I
agree.
And the experience wasn't quite there for me, but at least not in the application and not in the interview in terms of redistricting, not as clearly as some of the other candidates.
So maybe a meets.
Yeah. Meets for both?
Yeah, I'd say so.
I didn't capture in my notes for Gibson Dunn. What did we say for other factors? Where did we land?
Oh, yeah, I didn't write down anything either.
I don't think we scored that.
Yeah.
Oh.
I think we kind of did. We talked about it, but I don't think we ended up scoring it as a group.
Yeah. We were kind of split up on the question of how to weigh prior experience with the commission.
Oh, right. Yeah, I mean, to me, for a litigation team, our identity and values are always present. Our goals I see as, if and certainly the entire commission needs to weigh in on this, but I think defensible maps and actually defending those maps, winning once we have defensible maps. To me, in that regard, I feel like they would, in terms of the goal of upholding maps and developing defensible maps, I would see them as exceeding.
Mhm.
Certainly, they were able to be a part of that process in 2010.
Right. I think it's also a goal, though, of maintaining and building the reputation of the commission
Of
for
course.
next time. And, you know, successful maps are part of that, but not all of that. So, yeah, in which case, I think some of the conflicts of interest concerns are relevant.
Okay. If we were to score that one, just so that we make sure that we're scoring across the board on everyone, where would you want to, where are you thinking you would fall on that, Commissioner Yee?
I'd say meets plus.
Okay.
I think that's reasonable. I think I would fall there too, just in terms of values. I don't, like ultimately what we're all working towards and what we all want in a litigation counsel is exactly what Commissioner Sidwani just stated, which is a firm that has the capacity to and resources to defend our maps and to help us to ensure that our maps are defensible. And so I felt confident in two of these candidates to do that. And but in terms of values, I'm they've been but
it's a hired gun,
business, right? They're a business.
They're hired.
They're a business,
They're
and I understand that. And so, so we would want the best firm to represent us and to help us through this process, especially now, given the current environment where voting rights have and redistricting has a lot we're very likely to be challenged in our maps, and so we want to make sure we have the best representation we possibly can obtain.
I agree.
Sure. Okay, it's 3:27. The latest we could go is 3:40, but maybe this is a good time for a break right now.
Sure.
Before we tackle our third applicant. And before we do that, I do want to apologize. I did get mixed up between the second and third interviews, and the long intros also pertains to the third interview, as well as Ms. Orden's background, and not to the second one. So I apologize to the Rennie group for attributing that to them. Okay, let's see, no public comments. So let's go ahead and take a break. Come back. Do you want a longer break, a little shorter break?
If we just do our standard 15-minute or 3:45 as almost at 3:30, something like that.
Yeah, let's say 3:45.
I think 3:45 too. I'm just curious. I think we have Commissioner Sidwani and I have a meeting this afternoon too, so we can't. I think we have a hard stop as well.
Correct.
Around
5 o'clock. Yeah.
5 o'clock.
Yeah, we'll try not to take it right to the limit.
So we have a little break between our next meeting.
Yeah. Okay, so see you all at 3:45.
Thank you.
Thank you. So we return to what will probably be the final segment of today's meeting of the Legal Affairs Committee. At this point, we are evaluating our final candidate for litigation counsel, the Stromwasser Wucher Becker applicant. So we can start with relevant experience. Very strong, I thought. And, the firm itself, all its 30-year history, focusing on public agencies, but then adding Mr. Becker and his long stint at the Department of Justice, including many redistricting cases. I thought that was very strong.
Just wanted to take a closer look at their federal court experience. Should that be an issue that we ultimately find ourselves in? And certainly I'm seeing here Monterey County and Santa Barbara County Board of Supervisors. Commissioner Toledo, any thoughts here in terms of relevant experience?
I mean, I thought, I think I thought their presentation was good. I thought their application was solid in terms of experience, and I would go with either exceeds minus or meets plus.
Mm-hmm.
I would say exceeds minus. Mr. Becker certainly exceeds for me. So maybe a little less so for the firm in, are you thinking because it's not a lot of election or redistricting experience specifically, as we said for the Rene group?
I think for me, it's still that this is, it's difficult to decipher Justin Levitt was built into this application, and it's really hard to decipher which pieces is which. And so, because Mr. Becker was added onto this application, and it's just difficult to make that distinction and to really understand what each individual is doing and their experience as well. But I believe I do think he has really strong experience when it comes to I mean, his resume is stellar, his experience is stellar, and it's just, if we're looking at the application, right? If we're looking at the application, it's just a little bit difficult to decipher, and that's not. It was a last minute change, and that sort of thing happens sometimes. I think certainly if the application had been written with him as the initially with him inside, I think it would look a little bit different. I just don't know what that difference would look like.
Right. Well, I'm looking at the application, and let's see. I think Professor Levitt's cases are broken out on pages 7 and 8.
They are.
Yeah, so that was pretty clear to me. Everything before that was the firm.
Just the way it's written. I mean, I think for me, it's just it's anytime you're substituting someone, it's not as easy, right?
Sure.
It's not as clear in the narrative aspects of it, less the case law.
Sure.
The list of the cases are pretty clear, but the other aspects of it.
Yeah. Okay, so maybe an exceeds minus.
I'm curious to hear from Commissioner Sidwani in terms of it as well. Just her thoughts about experiences.
Yeah, I mean, I tend to agree with you on this. I mean, my sense is that there's somewhere, in terms of experience, that there's somewhere between the Rennie group and Gibson Dunn, right? That I certainly think that there's a broad array of experience here in terms of state court, federal court. Their strength, as far as I can tell, is really in the similar to Rennie Group, is in the representation of state bodies and commissions, which is very good, very positive. Their election experience, however, I think is reliant more so upon Mr. Becker. And I think as Commissioner Toledo is saying, like, it's clear to denote the distinction in terms of the cases, that Professor Levitt was taking on, on page 7 and 8, as Commissioner Yee identified. That of course makes for a very strong application, but if Professor Levitt is no longer a part of this. So there are some, there's definitely some voting rights issues, but again, these are voting rights issues, right? Voting rights. I'm looking at, for example, the Board of Supervisors for the County of Santa Barbara case. This is all on page 7. County of Monterey, again, a voting rights issue. Again, Padilla v. Lieber voting rights. Those were all Stromwasser and Wuscher. VRA specific, which is good. But I think there's a host of other challenges that we could receive. That's not to say they couldn't represent us on those issues. Hard to say exactly what their experience level for those other issues might be.
Remind me if was Mr. Larson, I know he was previously with Morrison Foister, was he there and did he work on our case or with the commission in 2010? Does he have experience working with, I believe he mentioned something, I just don't see it in my notes. Whether he was a part of or he has experience with our work from 2010.
It does not mention that in his bio.
Yeah, that's a really good point.
I thought he mentioned something, but maybe I'm imagining it. I just didn't take it down that he had been, I thought he had participated in that process. But maybe I'm imagining it. We've gone through so many interviews over the last couple of days. They're all starting to blur.
Imagine the auditor when they were interviewing all of us. Oh my goodness.
Oh my God.
120?
I can't even imagine. I cannot even imagine.
One after the other.
Yeah.
Well, we gave Gibson an exceeds. We gave Rennie meets plus. So in between would be a exceeds minus.
I'm comfortable with that.
Me too.
Okay. Personnel. We got to meet Mr. Stromwasser. Let's see. Yesterday, I think we gave them an exceeds, for VRA.
Mm-hmm. I don't know that this bears any. I'm trying to think if it bears any consideration for me or not. I don't think so, but I'll raise it in any case. One just comparable difference between this team and others that we've seen. Many of the others had a younger associate who was a part of it. Even if we, if we're thinking about Mr. Cohen for the Rennie group or Deb's, my word.
Sauer. Yeah.
Yes, exactly. I don't know that if that bears on our decision making at all. I'm not even sure if it bears on mine, but it is a difference at least. Between the three in terms of their personnel. They were all very senior members of their team. Presumably that's a good thing. Just remind myself of the others. We didn't, of course, hear from Salvador Perez, but again, he sounds rather senior also. Okay.
Mhm. And here's where we insert my premature comments about Ms. Orden and her mention of her background.
Yes, yes, that's correct. That's correct.
So we repeat the same rating for them as exceeds, just what we gave them yesterday.
Well, I wonder. How many members were on Gibson Dunn's team in total? I'm just trying to remind myself of that.
5.
6, I thought.
See, 5 came.
5 came. 6 listed, I believe.
Yeah.
1, 2, 3, 4, 5, 6. 6, same actually. Same here.
I guess I'll ask the question in terms of how do we feel about this group's ability to this firm's ability to, if they were to get both, and I'm just hypothetically, if they were to get both awarded both contracts, their ability to do both of the scopes of work with relatively the same people. I don't know if we got an answer to that. I don't believe we asked that question. I think they tried to answer a piece of it in one of their responses. But just their capacity to take on both of those sets of work, and whether there's benefit to having one firm do both. There might be potentially some benefit from a cost perspective, but there may also be some downside to that as well. So just curious about your thoughts around that. And it does fit into personnel because it is a personnel capacity issue, whether the firm can specifically was able to address that, given that they're applying for both applications and 2 different contracts that are, and the timing of the work might be different, but we don't know that for sure at this point.
I think that's a helpful way of framing it. So I thank you for that, Commissioner Toledo. I think I couldn't quite put my finger on what I was thinking about in terms of like counting the number of personnel, or the fact that there's more junior associates versus more senior associates, or more kind of this equity of all senior associates, it seems. I could envision, if we are utilizing the full team for VRA purposes, certainly our potential litigation risk is much broader than only VRA analysis. And would it be beneficial to have a team that has a greater depth, I suppose. The junior associates who can be helping with additional research and other components. Not to say that the senior associates wouldn't do that as well. I'm sure they would. When it comes, I'm trying my best here to really focus in on and just think about Stromwasser in the capacity of litigation at this stage. But of course, and I think they raised this at the end also, they've applied for both. And so it does become a little bit more complicated to procedurally to be scoring and ranking, also recognizing that they were our leading candidate for VRA as well. Would we benefit from having a secondary or a team for litigation purposes?
We're having the same team as well, right? There might be a
or having the same team. Absolutely. Absolutely. And as you noted, pros and cons to both approach.
Right, pros and cons. For me, it's one of those imponderables. I mean, if they're applying to both, I have to believe in good faith that they're adequately staffed for both or either or both, and would manage their own workload and other work they accept, accordingly. And yeah, pros and cons for having the same folks. It kind of just depends on the actual advice we get at each stage, right? Whether it's good advice. I guess we're kind of playing the odds on what makes for a higher likelihood of better advice. There was that one consideration of having the same voice involved with the drawing, with the mapping stage versus the litigation stage, and how a court might actually give more credence to a different voice, looking at it with different eyes. The group did try to address that, I think, by saying, you would bring in outside experts to testify. But that would be different than bringing in a whole different firm. So at the same time, at least two of them said, yeah, this is a dream situation if you could be a part of both the creation of a situation and then its legal defense. So.
And remind me if I'm incorrect, Ms. Commissioner Yee, but my memory is that we did have the 2010 commission did have one RFP for legal counsel, right? It wasn't broken out into VRA and litigation counsel. So maybe did we break it out this time around because we thought there would be a benefit to having two different councils, and I wasn't part of that process, so that's why I'm asking. I believe it was you and Commissioner Sidwani who took the lead on that as part of the VRA subcommittee. So I'm just curious your thoughts around why it was broken up into two and maybe two different RFIs, and also just the thought process around that, and if the 2010 experience, contributed to that decision, or if it was merely an effort to a recognition that it's two different sets of work.
Right. So as I recall, we just from the beginning we looked at it as two very different tasks that could interest two very different kinds of firms. So the VRA, we always said all along, did not have to be a California firm, whereas litigation would have to be, since California Supreme Court would be the primary venue. So at the same time, I think I'm recalling we always, at least from very early, we, considered the possibility that it could end up being the same firm. And we always thought, well, they could always apply to both, So I think, we were open about that. We didn't feel strong in one way or the other. We cared more just about the quality of the applications we actually got.
Yeah, I think that's right, and I think that the decision to do two separate RFPs really came from that feedback from 2010. That VRA expertise is something very different from litigation expertise, and it's possible that one firm could have both, but it's not always necessary. And so to create the strongest pool of candidates, which I think we've done. I mean, I think we have very strong candidates in both pools in general. we had always said, let's keep it open and have in front of us the greatest number of possible options. And I think we do have that, right? I mean, I think, if we were on the VRA side, if we were to go with one of the other candidates, then we have still a whole range of options on the litigation side. So it's that was done intentionally to hopefully put the commission in the best possible position to get the best legal advice possible, both on the VRA as well as all of these other issues in which we might face potential litigation.
By the way, I got a note from staff about the 2010 budget and the handoff from Gibson Dunn to Morrison Forster. Apparently that I had forgotten. That was probably a budgetary matter when money ran out. Gibson Dunn put a brakes on their work. At that time, Morrison Forster was willing to stay on in the hopes of a further allocation, which ended up happening. So it was surely financial at that point. But I should really research the whole history before I actually say more. Probably already
sure.
revealing too much ignorance. Okay, so back to personnel for Strumwasser Wucher. We gave them an exceeds for VRA counsel. I feel the same way, especially with Mr. Becker. I mean, I know we're still a little hesitant because he came so late and we just haven't, and we don't have a long experience with him that we had with Professor Levitt. But everything I've seen and everything I've heard, I think he was a fantastic pick for them as a replacement. And I think fully the equal of Professor Levitt and what he will bring to the effort.
I think I would give exceeds minus just because I'm not so clear about, just in terms of the application and the interview. I don't think, especially for litigation counsel, with such a broad scope and you're dealing with more potential issues. Because it certainly has very strong voting and voting rights and electoral experience.
I would tend to agree with the exceeds minus.
Okay. That's fine. I can go there. For the team as a whole.
Mm-hmm.
Okay, for plan, we've been giving everyone just the meats. Skip over that one. Conflicts of interest. We gave them an exceeds for the VRA.
Are you suggesting we maintain the same? I'm fine with that.
Yeah.
Yeah.
I think so. Yeah.
Agreed.
I'm fine with that as well. I'm always curious about what we mean by exceeding with conflict of interest.
Right.
or you don't, but maybe they gave us more information and we're more straightforward. I can see that. So yeah, and I'm happy to agree.
Yeah, that's right. I think, didn't we say that actually for the first one, that conflict of interest is always meets plus or meets minus or just meets, that it would be hard to know if you've exceeded in all of your discosures, because
like, what would that mean?
Right, like I had a conversation with a legislator once.
Right, but it is a little subject.
You wrote a book about it.
Right. So perhaps meets plus then in that regard, if we're keeping everyone kind of in the meets range.
Okay. Fee structure. Let's see. They emphasize coordination without duplication. Mentioned the metric of the court set fees being typically double what they're proposing.
So are we saying exceeds on this?
Let's see. So page 15 is on their application is where the fee schedule is.
I mean, if we give the Rennie group exceeds, I guess it depends on completeness, clarity, and coherence is what we're looking for.
Right.
Not
Amount.
amount, exactly.
Yeah, I would say this is at least the equal of the Rennie group. So,
Mm-hmm.
so say exceeds for that. Okay, down to the interview itself.
Well, I think as you noted earlier, they certainly heard our commentary yesterday, acknowledging what diversity they bring, and even talking at greater length about the importance of communities of interest testimony and the role that the importance of that more qualitative data.
Yeah.
So
which is it's good. It's positive for me. Yeah, they're responsive and teachable. What else to say? Yeah, I appreciated that insight into timing of possible challenges to the maps. That was a clear explanation.
Sure.
In terms of just values and commitment to the work of the CRC and our commission, I didn't hear anything that was against our values, right? And certainly everything that was said was certainly aligned with our values, both in the as far as I can remember from the interview and also in the proposal.
Well, right, and the fact that both they and Renee, their focus is public agencies, public law. A little plus there for me, not just hired guns. I'm thinking maybe exceeds minus for interview. I thought it was solid for sure, but maybe a little uneven in presentation. I mean, just it's almost trying to say something just to say something. But yeah, the little bit long on the intro and not I don't know, not quite as polished as Gibson Dunn. I don't know. That may be a positive or a negative.
Yeah, I would agree with your assessment.
Yes.
Exceeds minus for interview. Okay, potential for effective collaboration and any other factors.
Trying to remember what we put for them for yesterday on this question. I can go look at my notes.
I mean, I think based on what I saw today and also in the proposal, it seems like they have the potential to provide to work effectively with the commission and with our stakeholders, with our staff. certainly certainly in terms of rapport and in terms of being having the expertise to provide us with competent counsel and help us think through our issues, I wouldn't have a problem.
Yeah, I do just want to raise, so what I had in my notes from yesterday for this potential effective collaboration was meets plus / exceeds minus. So I'm not sure if we landed on which one that was. I do just want to raise, right, because, and there's no problem with the fact that they've applied to both, but it does give them that advantage to update their responsiveness to us. And certainly we've identified that they did, right? We raised yesterday in our discussion issues around diversity, as well as I think I had said something along the lines of them, you know, Mr. Becker being kind of an inside the beltway perspective. Right. You talked at length about communities of interest, which I appreciate. But you know, I don't know how I feel about updating that excessively. You know, I think, as he said, he has been in DC for 22 years or whatever that final number was. So out of fairness, I think on this one, certainly the role for which we are looking at them for is different. It's for litigation, not for VRA, but I see this question as still being about the same as yesterday. And so I think for me, out of fairness, I would keep it at about the same. Though I recognize that there was this updating that occurred.
I mean, I would hope that they would be updating, right? Especially if you have the opportunity to do so, because because we would want more information, not less, based on our assessment. I'd feel comfortable with either. Exceeds minus or meets plus.
I don't know if you know, Ms. Yang has any thoughts on this, given that this is for them, it is a unique situation. So just procedurally, we have one candidate, right, who is in both pools. This question in particular for potential effective collaboration, to me, feels about the same. It's measuring the same variable, if you will, between these two candidates. So I think that's, to me, the only question procedurally. If I mean, ultimately, and my guess is it's at the discretion of the commission, but I don't know if Ms. Yang has any thoughts on this, given the unique nature of having one candidate in both pools.
Ms. Yang, are you there?
Can you hear me now?
Yes, there you are.
Okay, great. So your guess is right. It is at the discretion of the commission as to how to decide that. I think the commission should keep in mind that their answers to as the VRA applicant and their answers as the litigation applicant should be separated.
So, Commissioner Samani, to clarify, is the question then, how do we weigh the fact that they had this opportunity to hear our feedback on their first interview and make adjustments for the second one, change anything? The fact that the other two candidates today did not get the benefit of receiving feedback on, or of gleaning feedback from comments about their previous interview.
So the way I think about it is that all of the candidates have had the opportunity to watch our deliberations for the past 2 days. And we've been a very transparent and very public process. And so any of the candidates have the opportunity to utilize, of course, the ones that come first are at a disadvantage, but but any of the folks that have come after, right, the interviews have been able to benefit and utilize that as well.
That's true. That's absolutely true.
Yeah.
And I would just, at least in my thinking of it, I am taking the interview and the application and what they said during today's interview and today's application and just scoring it based on what they said today. And yesterday we scored based on what they said yesterday.
Right.
Fair enough.
So on the split, I would probably lean high. I like the overall firm. I think this is the kind of work they do. So I think the potential for collaboration is excellent. So I think so an exceeds minus for me.
I would support that.
I can support that.
Okay, other factors. Yeah, once again, well aligned with the commission and values. The firm, but even more so, Mr. Becker. I think he brings a long track record and manifest commitment to fair elections and voter participation, and that's right down the same alley as the commission. Very, for myself, I keep thinking of being on the commission as a way of being on everyone's side, and that's definitely the impression I get from him as well. At the same time, yes, a late edition, which makes it maybe a little weaker as an application. So maybe an exceeds minus.
I think the interview was strong. I think the application for me still is a little bit weak. Not weak. I mean, I think it was strong as with Justin Levitt, because it was written for that purpose. I think it's just not having that it's just a changed application to me, right? And I completely understand that these things happen, and so I'm just trying to understand and how this all would work, and in terms of qualifications and experience and skill and ability to represent us around redistricting issues. But certainly a strong application as well. I think all of the applications were strong.
Where are either of you landing in terms of a score, do you think?
You're on mute, Commissioner Yee.
That's why you didn't hear me. I would say exceeds minus.
Are you comfortable with that also, Commissioner Toledo?
Yeah, it's either exceeds minus or meets plus, somewhere in there.
Yeah, I agree.
Okay. So we're down to the showdown. You line them up before me.
And I think it's very clear that Gibson, Dunn, and Stromwasser, which are our top two contenders, based on all of the scoring.
Yes.
Are we prepared to, given that we have a scoring system set up, are we prepared to move into discussing a full recommendation for the commission, including VRA and this? I think it would make sense to discuss them jointly at this point, given that one of the candidates is an applicant in both pools.
Perhaps we should ask Council Yang just on procedural advice in terms of considering them jointly at this point.
We're not hearing.
Yes, it looks like she's still on mute.
Yeah, we're not hearing you, Ms. Yang.
Yeah, I'm sorry. I have to unmute my phone and also unmute on the screen. Apologize.
No worries.
So the commission ultimately has to make two decisions, one for each contract. So I think for processes wise, it would be, I guess, more streamlined if the decisions were made separately for each contract rather than together. But I'm not quite sure how the commissioner's plan is in deciding the contracts together to make the recommendation to the rest of the commission. But in my view, it seems that for process-wise, that the decisions should be made separately for each contract.
Okay, makes sense.
Commissioner, just a quick question, or Chair Yi, do we have our public line open in case any members of the public have feedback on either of these applicants or on either of these RFIs?
Yes, it's been open since after the end of the interviews when we came back to that session.
Thank you. That's what I figured. I just wanted to make sure.
Yeah, and yeah, thought we would have more interest, but that's okay. Maybe we're doing such a good job. No comment.
Certainly being transparent, at least. Yes. I wonder then if it makes sense to go back and begin with VRA and make a decision there first, and then move on to litigation and take them in that order, perhaps.
Sure, that's fine.
Just in terms of time, it is 4:30. Just curious how long we can be here in terms of the time commitments, but also in terms of the staff.
We're all set until 5 o'clock.
So is our intent to go through 5 o'clock, or can we go later?
Our intent is to go no farther than 5. I think both of you have a hard stop. Yeah.
Okay, thank you.
And hopefully, yeah, not right to 5.
Which only gives us 30 minutes, so that's why I was.
I think it's worth having the opening discussion of it, and then we can always pick up tomorrow as need be.
Yeah, let's go a solid 20 minutes at least, and see how far we get.
Okay, sounds great.
Okay, so VRA Council. Looking back, we landed on a ranking of Stromwasser-Wucher 1, UCLA 2, and then Krimkard-Aiken 3. How are we feeling about that the next day?
I think my sense is that one of the things that we have heard now a couple of different times is that having a independent VRA assessment in addition to a VRA attorney can be very valuable. We certainly will need RPV analysis. I would feel very comfortable moving forward with Stromwasser-Wucher and certainly this would need to be a conversation with them if we were to move forward and advance with them. But for me personally, having UCLA provide that analysis, conduct the RPV analysis, and provide perhaps a broader Section 2 analysis. I mean, I think in 2010, Matt Barretto did that individually, and now, of course, he is a part of this much larger entity. I would be curious to find out more of what that could look like. And I think that would be a way of us getting access to our top two candidates, really, just in a different sort of scenario. We will need someone to do RPV analysis regardless. And certainly I think that UCLA team provided a strong argument in case for their ability to do so.
Right. And that is under our discretion.
It is absolutely.
Yeah. Whom to choose to do the RPV work.
And that would be a separate RFP or a separate procurement process for the analysis, the RPV analysis.
Yeah, it would be separate procurement. Because it's UCLA, my understanding is that it could be an interagency agreement. There wouldn't need to be an RFI or RFP.
And there would be that whole question of whether the attorney privileged requested from our new chief counsel or from Strumwasser.
That's correct. And I think that regardless of who we go with for our VRA counsel, that is a question that we're going to have to answer. I think it's a question also for our potential litigation, our litigation team as well, because ultimately whether or not we release it is a question of potential litigation.
Yeah. Litigation strategy.
Litigation strategy. Thank you very much.
No, you said it right.
Okay, so the recommendation would be then to retain Strumwasser-Wucher for VRA counsel, and then to intend to pursue UCLA for RPV work.
What do you all think about that?
I like it. Yeah. I think it plays to the strengths of the two different teams and would serve us well.
Yeah. Commissioner Toledo?
Yeah, I would be supportive of that as well. I'm wondering if the RPV analysis is a different conversation, or maybe it is the same conversation. Today, I think we're trying to make a decision on who the VRA counsel is, and maybe because you guys, the two of you, are the VRA subcommittee, and so so certainly if that's your recommendation, I am happy to make that recommendation to the full board.
Yeah.
And to join you in that.
The way I see it is, yes, that our purpose here is to make a selection that we would recommend to the full commission for VRA counsel. That recommendation is Strumwasser-Wucher. I think immediately upon entering a contract with them, assuming they are in agreement with it, the conversation should occur about what kind of RPV analysis we should have, what that process should look like, and who it is that should conduct it. I think what we're saying out of this conversation is that we would have a desire, an intention to see the UCLA Voting Rights Project conduct that analysis. As opposed to, for example, it sounded to some extent today like Mr. Becker was suggesting that his organization could conduct that analysis also. And I think that's a reasonable thing to still look at in greater detail. I don't think we've exhausted the conversation yet about RPV analysis, but I think what we've seen here is that UCLA can provide a strong assessment in that regard. But by no means is it a final recommendation. I think that the recommendation for RPV analysis should come in concert with our VRA counsel. Does that make sense?
It does, and I'm just wondering if you want to make a motion.
Oh, do we need to vote?
I believe we will have to vote for a recommendation to the full board.
I believe so, yes, in the end, but that can wait till
we do the
votes.
other piece, if we can get to agreement. Okay.
Very good.
Okay, so litigation counsel, your candidates. I would say Strum, Wasser, and Gibson Dunn scored higher, just on in terms of exceeds, meets, lags. Renee was solid, but not as many exceeds. Only one exceeds, actually, the fee structure. Gibson Dunn had more exceeds versus Strumwasser more exceeds minus. On the other hand, Strumwasser had more exceeds plus exceeds and exceeds minuses taken together versus Gibson. Gibson had 4 exceeds. Strumwasser had 6 exceeds or exceeds minus.
It sounds to me like there's no real that they're pretty much that based on our assessment that was pretty equal.
Pretty equal.
Is that correct, or you have the documents in front of you?
Yeah, I do. I at first I was about to assign numerical values and try to get an actual numerical score, but we've been trying to avoid doing that, so I'm not going to do that. But yeah, I would say basically overall about the same weight on those evaluations. For me, the conflicts of interest meets minus, lags plus weighs pretty heavy. It's garnered that one item has garnered probably the most public comment on anything that we've gotten any public comment on, even though that's not a lot. Even so,
I would agree with that. Certainly, that is a concern, and I think that we have most certainly done our due diligence to unearth anything that we were concerned about, and I appreciate the public's participation in that process as well. Ms. Reed calling in on both days, identifying them, and so I share with you those concerns. However, I also want to think about positioning the commission to be in the strongest possible place when it comes to litigation. And I think we've already decided that Strumwasser-Wucher is going to be a part of our team. To me, then, I think if we add Gibson Dunn to that, we would be in a very strong position for any kinds of litigation that comes before us. And that ultimately what that would be suggesting is that the two teams need to work together to some extent, and depending on any potential litigation that comes before this commission.
Yeah, I mean, I see your argument, and certainly it feels like lawyering up to a higher level to have the two different firms. For me, that's balanced though with the additional. It seems like if we do have one firm doing both, that adds a deeper level of detail, skill in the ability to finally connect what we do at one stage with what we might need to defend in another stage. Again, that's just hypothetical at this point, but it seems to me there's still a significant capacity for that. A greater capacity with one firm doing both than the two different firms. Although, it could go both ways.
Commissioner Toledo, do you have any thoughts on this matter?
And just looking at the application and looking at and thinking through the interview process, I'm still, the substitution piece makes it hard to assess the application. I thought the interview was very strong. The application and the physical document that we received, and of course that's no, I understand things happen, and so but it is I'm having to interpret this a little bit more than I the other applications for litigation counsel where the substitutions haven't happened, right? And so for me that does weigh in a little bit and factor into the equation. I mean, certainly we allowed for the substitution, and they had the opportunity to provide additional information, and I'm taking that into consideration as well, as we all are. But it's still not, when you set out to write one of these proposals, and you write it with the people in mind, right? Your team, your human team, and the team has changed, and so the proposal normally would change, and so it's a little bit harder to assess. And so the interview was certainly strong. I felt confident in their abilities. I'm having a little bit harder time just. And I think I mentioned this a couple of times, just rectifying that change and how in reading it, it just reads a little bit differently. So I actually, given that, I felt that the Gibson Dunn application was, in my perspective, a little bit stronger, just because there was no change, and it's really easy to. Certainly, they changed who came to the interview, but the people were the same, right? The proposal was the same. That everyone who came to our interview today was included in that interview, in that packet, and was described. Their role was described in that packet. So I am leaning towards Gibson Dunn being a little bit stronger, based on that, both on the personnel. So it's really a personnel issue, right?
Mm-hmm.
Mhm.
With Stromwasser, Mr. Stromwasser himself, I think, is part of the litigation proposal, but not the VRA proposal. Is that correct?
That's my understanding as well.
Yeah. So it's a bit different personnel. Yeah. So we would have that additional participation. Yeah, I hear you, Commissioner Toledo. I think for me, I guess I am just very impressed by the pick they made to replace Professor Levitt, and at least on paper, and then what we heard in interviews, I felt like it's a little bit being just inferring from what I heard and what I saw. I felt he was easily the equal of Professor Levitt in what he brings to the team, and I would expect him to. I don't expect the team to have lost anything in the swap. I mean, they're different men, of course, different backgrounds, but in terms of the task at hand, I thought they brought equally as much. But I hear you that it is a change, and it makes it a little shakier as an application.
I mean, and it was our discretion to allow for the change, so I understand that. If we could have also used our discretion to say, no, we're not going to allow the change, right?
Yeah,
and so that is, that's not factoring in my decision making at this point, but that is something that, out of fairness and equity to the other applicants. I totally understand that things happen, right? Life happens.
For me, the two firms both have their strengths and they both have their weaknesses. Having both of them on our team means we get to tap into the strengths of both of those teams. And to me, if the goal is ensuring the commission's process and ensuring our work forward, and ensuring we're on strong legal ground, being able to play into the strengths of both of those teams is very exciting. It's an exciting opportunity. My sense is that the work with Stromwasser-Wucher as VRA would definitely be front-loaded, that our work with them would need to take off very soon. We have this time before the census data. I think we've heard from many of the applicants, both yesterday and today, that we can be using this time to do our VRA assessment. So I think that we would begin to work with them, immediately. Whereas the litigation team, if we were to move forward with the secondary litigation team in Gibson Dunn, I think we might have their presence available to us, and again, negotiated. It sounds like it would probably be a junior member, simply to kind of keep an eye on things and report back to the larger team, flag any potential issues. But when necessary, I think that they certainly have experience in very high level cases. And should that become the case for our commission, and as we've discussed, there's a number of possible litigation opportunities that people might explore or attempt, I think we would be on solid footing to have them be a part of that team. That being said, right, if we look at the example of the 2010 commission, it seems that they did add on the secondary litigation team later. And again, I don't have enough of the background or history there, but making a decision today does not necessarily preclude us, I'm assuming, and maybe Ms. Yang wants to weigh in on this a little bit more, but as we move forward, if we decide that we need, different counsel or a different team or the creation of a different team, I think that's still something that we could look at later on, right? It could be the case that we take on Stromwasser-Wucher as VRA, Gibson Dunn as litigation, but depending on the kinds of litigation that we ultimately face, that a different team is needed in the future, and we would have to cross that road when we get there, regardless.
Curious in terms of our rating for experience. I know when we talked about experience for Gibson Dunn, we also weren't certain about how to consider the past experience with the 2010 commission, and especially in light of some of the especially in light of the change that happened with Morrison Foster. I think at this point we've realized that it was purely, in my understanding, and I could be wrong, and I think we may not have all the data here, and we can certainly get it through reference checks, but that it was mostly a monetary issue in terms of some of the fiscal challenges that the commission was going through back in 2010. And that but I'm wondering if we considered that in our deliberation. I remember we did. I remember how it weighed and whether we would redo our scoring on that based on additional information at this point.
Right. Well, we did discuss that. We do seem to have missing pieces of the story if we wanted to weigh that in more as a factor. But it is 4:52. And I don't want to take it right to the hour. So it looks like we will need to continue this discussion tomorrow morning. I hear both of you that you're leaning towards Gibson Dunn. I find myself a holdout on that and need to hear more. So I will do some more research this evening, and you can too, of course. And we'll resume tomorrow with public comment and continue this discussion. Hopefully won't take all day. And hopefully come to a conclusion tomorrow. Okay, so let's see, we've had public comment open this whole time, so I don't think we need to reopen it specifically. So if we can I think we can just recess, right? Okay, so we'll recess to tomorrow at 9:30.